All right, we'll call this meeting to order, the State Board of Accountancy. A couple announcements. This meeting was properly noticed by having the agendas placed on the board's website on Monday, April 21st, 2014. The board will be electing officers for the coming year at the meeting in July. Current board policy states that officers may only serve 2 terms, and the current slate of officers have served 2 terms in office. Therefore, nominations for chair, vice chair, and secretary are in order. Please send your nominations for the officer positions to Mark so that he can reach out to nominees and determine that they are willing to serve if elected. Ms. Brundage and Mr. Stewart will not be with us today as they had unavoidable conflicts in their schedules. Excuse me. I also want to remind the board members that they should speak up and speak into the microphones. If the red light is not on, then they are not being recorded. With that, Mark, do we want to go ahead and approve the minutes from the previous 2 meetings, I guess? We had a telephone conference and a January meeting.
Mr. Chairman, may I make one quick comment?
Oh, I'm sorry.
Unfortunately, I have to leave today at about 5 after 11, so I just want to go ahead and put that on the record, and I apologize sincerely for an unavoidable conflict on my schedule.
Got it. If everybody would review the minutes, and I'll entertain a motion to accept the minutes.
Make a motion to approve as presented.
I have a motion on the floor. Do I have a second?
Second.
I have a proper second. Any discussion? Hearing none. All those in favor of adopting the minutes, please signify by saying aye.
Aye.
Minutes are accepted. Mark, you want to go ahead with your executive director's report?
Yes, thank you, Mr. Chair. If you'll notice in my Executive Director's report, I made reference to NASBA activities. The Executive Director's Committee met in Savannah on March 3rd through 5th. I did note that some of the more interesting topics that we discussed, background checks on CPA exam candidates, legislative update in the software that John Johnson at NASBA is using to track introduced legislation for the 55 jurisdictions, the federal agency outreach, and the effort that NASBA is putting forth to build a relationship with these agencies so that we can operate together to protect the public. CPE tracking was a big topic and a big issue, and we will be discussing that later in our board meeting. And of course, Ian Dingwall's presentation from the Department of Labor. Apparently we're having some difficulties with employee benefit plan audits. Wendy Garvin from TSCPA will be addressing this for us a little bit later in the program. I did attend the regional directors meeting and the board of directors meeting for NASBA in San Juan, Puerto Rico. Got a listing there of the other meetings that I attended. The State Board Committee is meeting again. I'll be going to Denver for that one. You have proposed future meeting dates. Please put those on your calendar. This gets us through the 16th of October of 2015 as far as future meeting dates goes. Peer Review Oversight Committee, I did want to bring you up to date on some information that we had for the PROC. You had requested some information from me at the last meeting. Here's what we've discovered. There are 50 jurisdictions in which peer review is required. Peer review will become a requirement in 2 additional jurisdictions in 2015. Virgin Islands and Delaware are discussing the development of peer review, and peer review has been passed in the Commonwealth of the Northern Marianas Islands, but their rules have not been developed yet. So it looks like we're getting peer review in all jurisdictions shortly. Currently, 26 jurisdictions have an active PROC or are developing a PROC. The 26 are broken down as follows. 15 have an active PROC, 5 have an inactive PROC, 4 are in the process of establishing a PROC, and 2 are planning on establishing a PROC. So of the 55 jurisdictions, you have at least 26 that are using a PROC or planning on using a PROC. Tennessee is among those. The size of the PROC committees range from 1 to 9 members. Here in Tennessee, we have a 3-member PROC. The AIC EPA Oversight Handbook recommends that no active board member should be a member of the PROC, so that eliminates your participation as part of the Peer Review Oversight Committee. 4 states have severe confidentiality restrictions on peer review reports. Those states are Tennessee, Indiana, Missouri, and Texas. And I think that this is where we perhaps need to look at the issue of peer review transparency. We are one of the few states that have these restrictions. Perhaps we need to loosen that up a little bit. In many states, the Peer Review Oversight Committee is a volunteer position and is unpaid. Here in Tennessee, we are not able to get volunteer PROC members. That's why we have contracts and we are having to pay them. We had to beg to get people to fill out the contracts. We seem to have a shortage of those interested in being on a Peer Review Oversight Committee. There are several jurisdictions in which several states have joined together to engage a peer review oversight committee because the individual jurisdictions are not large enough to have their own PROC. 2 or 3 states have gone together. They have one peer review oversight committee that does all of the work for those states. I think Tennessee is probably large enough in regard to active firms that we need our own peer review oversight committee. I know that we're looking at the peer review oversight committee process and the structure. If we're going to do something here, I recommend that we work with the society, create a task force to look at our law and rules to determine whether or not we want to pursue using the PROC as it is established. I don't see another option out there, but perhaps a task force could come up with some type of recommendation. I think the rest of the report speaks to itself. I will like to mention a couple of things that are not included on the report. The NASBA Eastern Regional Meeting is June 4th through the 6th. I have made application for Mr. Brewer and Mr. Haas and myself to attend that meeting. That is part of our travel plan for the Executive Director and 2 board members to attend. So that is within our budget. Mr. Brewer and Mr. Haas will be attending the new board member orientation on Wednesday so that they can see how other boards operate and how an ideal board operates. I'll also be attending the NASBA Western Regional, which is June the 11th to the 13th. That is part of my duties as the chair of the Executive Directors Committee. We will be having an ED committee meeting on Saturday following the Western Regional. The department has looked at the RBS system and the new core system that we are going to for our licensing database. We have a significant number of CPAs for whom we do not have Social Security numbers on file. The department is requesting that we get those Social Security numbers from our licensees. So we will be sending out letters to our licensees for whom we don't have the SSNs, requesting that information. Wanted to let you know about that just in case you got some calls on that. In personnel issues, Ms. Christy Burton has, Henry?
You may run into some pushback on that from a lot of people not wanting to give their Social Security numbers, especially anybody that's been involved with any kind of identity theft may have a problem with that. I personally hadn't thought very much about it until about this past year, and I got hit twice with identity theft issues, and I've just quit giving my Social Security number out to anybody. And so there may be some issues there that we might run into, and if there's, I would really want to know what the need for the Social Security number is in order to give that number out. And then I would also like to know about the security aspect of it, how secure the database is with this information.
Well, there is a statute in another part of the law that states that if you are issued a permit to practice for a regulatory board, we must have a Social Security number on file. It's not part of our statute, it's part of an overriding statute. And the division has decided to enforce that particular statute. As far as I know, Henry, our database is as secure as it can be. I can't speak to the security. You'd have to get someone from the IT department in here to talk about that. I know that we've not had any issues with our information being hacked. Chris, do you want to?
1 second. I need to speak with Mr. Crocker about that. Thank you for your patience. As Mr. Crocker was kind enough to remind me, I was trying to search for the title under which the Social Security requirement exists. I don't have an exact statutory side in front of me, but it's in Title 56 under insurance, I believe. And because the Regulatory Boards Division, of which the Accountancy Board is a part, is under the Department of Commerce and Insurance, I believe that, that the statute being discussed is applicable to all regulatory boards and not just this one. And that's, I think that's where we are right now.
Crocker, I would think that, if we're in the position that we're in as a regulatory board, and every client we've got their Social Security numbers, and we ought to be willing to give our Social Security numbers to our regulatory board as a requirement without hesitation. Is personal on that. I mean, I've had identity theft clients as well, not personally, thankfully, at this point, but, I think if we're going to license somebody, they need to comply with whatever the statute is, particularly since it's not us requesting it.
Certainly. I appreciate that, Mr. Royston.
We used to put our Social Security numbers, for those of us that have a little bit of gray hair, instead of having a P10 number on every tax return we file, so ours are well published out there anyway.
I will point out that all of the new applicants are required to give a Social Security number. What we're looking for are those that are older licensee files where perhaps when it was converted in 1993, the Social Security number was not input. So it's primarily the older licensees that we'll be dealing with here, Henry.
I would assume that you use that number to do background checks. Is every person that's licensed have a background check?
No, we don't do background checks. The Social Security number is there for identification purposes, is my understanding.
I'm not going to win this argument, so let's go on.
In personnel issues, I will tell you that Ms. Christy Burton resigned effective April the 18th. She took a position with the federal government, making a significant amount more, so we were unable to keep her. We will miss Christy, and I wish her well in her new position. Ms. Turner, who is our office manager and firm permit coordinator, has advised me that she will be retiring as of June 30th, so we'll be losing her as well. The firm responsibilities will be transferred to Ms. Condon, and just want to let you know what personnel is up to. And I think that's it, Mr. Watkins, unless there are questions on my report.
Are we attempting to hire for these positions?
Yes, I have prepared the memo to go to Commissioner McPeak to fill Ms. Burton's position, and I've got to talk to personnel about how to go about filling Ms. Turner's position.
Condon's doing just about everything now, right?
Turns your head around.
Yeah, that's right. Okay, thank you, Mark. Any other questions for Mr. Crocker? Okay, hearing none, I guess we will have to take a break here till 9 a.m. Is that correct?
Yes, sir, I believe that would be the proper thing to do.
Okay.
And let's get set up for the formal hearing.
All right, we'll take a brief recess till 9 a.m. Troy, you want to go ahead with the law and rules?
Sure. The Laws and Rules Committee did meet yesterday at 1 p.m. We had 3 items that were on the list. The first item that we discussed was we had a little discussion of the exposure draft on the UAA regarding a test. We just compared the UAA Act exposure draft as compared to our rules and our guide. I think the two large items I guess we talked about was one, in our state, a compilation falls under a test, and I think it's that will remain. There will be no change in that regard. I think there's too much involved with that anyway. And then our other item, we went through the list, and I think the one thing, I think we tabled it for more research would be, but our PC AOB, the Private Company Accounting Oversight Board, is in the UAA attest definition as part of that, and I think there were some issues we needed to discuss about that before we would decide on whether or not to add that to the definition. Our next item that we discussed was we reviewed the rule 0020-01-13-2C regarding renewal of reciprocal CPA certificates. I think that rule, if you open your guide, is on page 40 on the top left of your law and rules guide, and I think that is attached to a change that we had previously made that was on page 32, and I think that is also on your top left page, I believe. And I think we wanted to make sure that we coincided the fees with those two rules. I think if you look in the rule book, it hasn't been changed yet on page 32. It should be, if you go to 0020-01-041C, you can see the fee is $120, which that has been changed previously since this book was written to $110. So, but more or less what we're doing is changing 13.2C to coincide with the same fee. And I think we passed that motion. And then our third item that was on the list, and this was Mr. Whitaker may present this at some time today. I think he'll enter this into the minutes. But we did it will more or less would be a review of regulatory flexibility analysis for rules with preliminary board approval, and he will go through that today at some point when we get to that point. Those were the 3 items that we discussed in our committee meeting. We need to make a motion of some type to accept the one rule change, or how would that, or is there a question or response to any of that?
Yeah, does anybody have any questions? Okay, Mark, what do we need to do here?
I think we need a motion to accept the report's recommendation to change the rule so that we can accurately reflect $110 for the renewals.
Okay. I'll entertain a motion.
So move.
Okay, I have a motion. Do I have a second? Second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Okay. Any noes? The ayes have it. Thank you, Troy. I assume you're good on the UA.
I will.
Hey, Mark, is there anything on Jennifer's board effectiveness and legislative?
Yes, actually, she did send me this report, and I'll read this into the minutes. The NASBA Legislative Support Committee met in Nashville on March 31st, 2014. The committee continued to discuss how to measure a board's effectiveness and the next steps for assisting interested boards in assessing their effectiveness and providing them with tools for improving their weak areas. We discussed the bill tracking system and successes from the legislative season. The committee is working on the development of a key person contact program. NASBA members and associate members will be sent a questionnaire survey and asked to provide information about their legislative administrative contacts so that NASBA and state boards can mobilize when legislation is identified. And that was Ms. Brundage's report, Mr. Chairman.
Okay, thank you. Why don't we go ahead, we got 5 more minutes here. We'll do the executive committee, because I think the other 2 committees will take some time to discuss. We reviewed financials yesterday. Actually, we really didn't have much of an executive committee meeting yesterday, but I did want to give Bill an opportunity if you had any questions.
I guess my question regarding the financials is that normally we would have some narrative to go with the financials to explain unusual variances, and particularly projected for the end of June.
Bill, I did not include a narrative. I will get that to you if you want one.
I mean, but on a going forward basis, it's helpful to have explanation as to why we have unusual variances from past experience against the budget.
Sure. I will get that to you.
All right, and then I had brought up a few issues yesterday that we were going to try to get the society a list of all applicants that have selected a test function on their firm permits, and we were going to try to share that with the society so that they can ensure that all firms are getting peer review that need to have peer review.
Certainly.
Okay. And then did we need to authorize you to work with the society on the peer review oversight committee? You said something about task force to...
I'd like for the board to select a task force of board members to work with the society. Of course, I'll be involved in that, but I think this is a board and society matter.
So do we need to authorize anything here?
You might want to ask for volunteers to serve on that task force.
Okay. Do I have any volunteers that would like to serve in that capacity? Not everybody at once.
Can we look at a time commitment on what you're referring to?
Well, this board is looking at options as far as peer review oversight committee goes. If you'd like, I can have Janice Gray from NASBA's Compliance Assurance Committee come in and talk to you about peer review oversight committee before you select a task force. She has a wealth of knowledge in regard to peer review oversight committees and how they operate. That would be my recommendation, is to wait and have Ms. Gray come in.
We determined that we need an oversight committee.
That's one of the things that this task force needs to look at, Bill. Our statute and rules currently require it, but that is something that this board needs to look at and determine if that's what you want to do.
Sounds like the #1 agenda issue.
Certainly.
Can we add that to the committee meetings at the next meeting, perhaps?
Sure.
And not sure if that needs to be the whole board or we need to have that discussion.
Mark, could you indicate what qualifications would be best for those serving or whoever's going to be on that committee to have? Specifically, what I'm asking is it preferable that they come out of an assurance background or a test background as opposed to tax?
Dick, I think obviously that would be preferable. You want someone who is intimately involved in the peer review process. I think in order to provide accurate oversight, you need to know what's going on. So I don't think anyone who has a tax background is going to be well qualified to do this.
And that's all I had for executive committee. Does anybody else have any questions? Okay, I guess we'll move into the formal hearing.
Very good. Thank you so much. Are you ready?
Yes, Your Honor.
Very good. We are here today in Nashville on May 2nd, 2014, for a hearing before the Board of Accountancy to consider the matter of John Hamblin Jr., and that's docket number 12.19-124014A. My name is Kim Summers, the administrative judge assigned by the Tennessee Secretary of State to preside over this hearing. Do we have Mr. Hamblin with us here today? Do you have the notice of hearing and charges to pass out to the board members?
One moment, Your Honor.
Okay.
Your Honor, it appears that I don't have quite enough copies for all the board members.
Okay.
So that would be just a second. I apologize for undercopying.
Okay. Well, we can just take a moment. If we could have someone make the copies and we can maybe move forward with the proceed. I'll have the board members review the notice of charges once we have sufficient copies. Again, I'm here to, as the administrative judge assigned to this proceeding, to make decisions on evidence, law, and procedure. Will not participate in making a decision on the merits of this case. That will be left to the members of the board to make that decision. And if I could have the board members identify themselves for the record at this time.
Gabe Roberts.
Stephen Eldridge.
Troy Brewer.
Don Royston.
Trey Watkins.
Bill Blofus.
Vic Alexander.
Henry Hoss.
Charlene Spiceland.
And Mr. Chairman, do we have a quorum?
We do have a quorum.
Very good. Can I have counsel for the state identify himself for the record, please?
Yes, Your Honor. My name is Chris Whitaker, Assistant General Counsel, the Tennessee Department of Commerce and Insurance Regulatory Boards Division. I'm representing the state in this matter.
Very good. And as we previously determined, we do not have the respondent present with us at this time. Is there a motion from the state?
Yes, Your Honor. In order to enter proof of service into the record, I will need to call what will also be my first witness, Mark Crocker, Executive Director for the board.
Okay. Would raise your right hand for me, please. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you, Your Honor. Mr. Crocker, would you please state your name and position for the record, please?
My name is Mark Crocker. I'm the Executive Director of the Tennessee State Board of Accountancy.
How long have you been Executive Director for the board?
October of 2007.
And are you also the custodian of records for the board?
Yes, sir, I am.
And prior to your testimony today, have you reviewed the licensing and complaint files for a Mr. John Hamblin?
Yes, I have.
And what is Mr. Hamblin's mailing address at which the board was able to locate and serve the respondent in this matter?
The address was 8833 Sawyer Brown Road, Nashville, Tennessee, 37221.
Thank you, Mr. Crocker. I'm going to hand you a document now and ask if you can identify it for the record, please.
Mr. Whitaker,
Yes, sir.
This Troy. Hey, this individual I actually went to high school with. So I wanted to make that known. When I heard the address and the last name, when I heard the name, I thought they recognize it. But this is a person that I went to high school with. So I want to make that known, and however that may.
You want to recuse yourself from this?
I think I probably should. I've known him for a long time.
Will we have a quorum, Mr. Chairman?
We will still have a quorum.
Thanks. Thank you.
This appears to be a green card, return service notification that Mr. Hamlin received, mail at 8833 Sawyer Brown Road, 2/18/14. It appears to be his signature on here.
Thank you. And based on your review of the complaint files from Mr. Hamlin today, is this green card in fact associated with the notice of hearing and charges that was filed in this matter?
Yes, sir.
And looking at the green card, does this green card appear to be signed by the respondent, Mr. Hamlin?
Yes, it does.
And as you mentioned before, what was the date of delivery on this certified mail and the notice of hearing and charges?
The date of delivery is February the 18th, 2014.
Thank you, Mr. Crocker. Your Honor, under the business records rule, I'd move that this matter be entered into the record as Exhibit 6. I have other pre-marked exhibits that will come in later, and I'd request permission to publish this to the board.
Okay. How does the state wish to proceed at this time?
Your Honor, based upon the proof of service of the respondent in this matter via certified United States mail, the state would move under applicable case law and Secretary of State rules to be allowed to proceed with this matter in default in the respondent's absence, and to move forward with the formal hearing in this matter today.
Well, I find based upon the respondent's signature on the green card that he did receive notice of this hearing today. Based upon that, it will be up to the board to determine whether or not the respondent will be held in default. And if they choose to proceed in the absence of the respondent, or adjourn the proceedings for a future time. In making this determination, you will need to consider the statutory definition of default. If a party fails to attend or participate in a pre-hearing conference, hearing, or other stage of a contested case, the administrative judge or hearing officer hearing the case alone, or agency sitting with the judge or hearing, may hold the party in default and either adjourn the proceedings or conduct them without the participation of that party, having the regard for the interest of justice and the orderly and prompt conduct of the proceedings. I will now turn the matter over to the board to determine how to proceed.
I'll entertain a motion, I guess, to determine whether or not proper notice was given and whether or not to try this case in the respondent's absence.
Just to clarify, I've made a determination
You did,
of
okay.
proper notice. The board determines whether or not the respondent will be held in default, and if so, how to proceed, that being going forward or adjourning and resetting the matter for the future.
I'll entertain a motion.
Mr. Chairman, I'd make a motion that we find the respondent, John T. Hamlin, Jr., as properly noticed and not presenting himself today. Motion to continue with the proceedings today.
Okay, I have a motion. Do I have a second?
Second.
I have a second. Any discussion? Hearing none, those in favor of the motion, please signify by saying aye.
Aye.
Any noes? The motion carries. Thank you.
Very good, thank you very much. I would generally have the board members review the notice of charges to determine whether or not anyone has any conflict with the proceedings. In the absence of that, at this point, I will go ahead and review the technical record, which consists of the notice of hearing and charges that was filed December 17th, 2013, a December 26th pre-hearing order. We did then receive returned mail from the respondent, a motion for continuance dated January 24th, an order of continuance dated February 4th, notice of service of documents dated February 5th, again returned mail from respondent, the state's witness and exhibit list filed April 24th, and notice of filing return on service by mail dated April 24th. Is the state aware of any other documents that have been filed that should be included in the technical record?
No, Your Honor, I don't know of anything else that's been filed in advance.
We did have Mr. Brewer indicate some personal knowledge. If anyone else is aware at this time of any personal knowledge of this matter, they can now so disclose this matter or the respondent. Okay, seeing none, if anyone becomes aware upon review of the notice of hearing and charges, if you could let us know at that time. Members of the board are reminded that during the time this hearing is being conducted, no discussion concerning this case should take place between board members or with witnesses, attorneys, or other persons unless all parties are present. During the hearing, the board sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all board discussions and deliberations to be in public before all parties. Failure to observe the Sunshine Law may result in the board action being reversed or remanded if appealed to Chancery Court. Again, you are reminded that you must disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from any parties concerning this case. Give the board members a few moments to review the notice of hearing and charges, and then we'll proceed with opening statements. Y'all ready to proceed? Do you make your opening statement?
Thank you, Your Honor. Good morning, Your Honor, ladies and gentlemen of the board. For the record, my name is Chris Whitaker. I'm Assistant General Counsel for the Department of Commerce and Insurance Regulatory Boards Division. I'm here today to represent the state in this formal hearing against the respondent, John T. Hamblin, Jr., for his alleged violations of the Tennessee Accountancy Act of 1998 as amended and the rules promulgated under the Act. In this case, the state expects to prove the following allegations. That the respondent has previously been disciplined by this board for substandard performance of professional services and for practicing on an expired license. That at all times pertinent to this case, Mr. Hamblin's Tennessee CPA license was expired. That the respondent's Tennessee CPA license was not timely renewed, and Mr. Hamblin failed to timely renew his license, failed to notify the board of his intention not to renew his license, and failed to surrender his CPA certificate, all as required by law for a CPA who does not wish to renew his or her license. Also, the state will prove that the respondent performed accounting services on that expired license, and that during the performance of services on an expired license, the respondent failed to exercise due professional care and to competently perform services during a client engagement, again, which was performed on his expired CPA license. For these alleged violations, the state will have a prayer for relief that will be presented to the board at the conclusion of the proof. Thank you. Thank you, Your Honor. State calls Mr. Mark Crocker, who was previously sworn.
I'm here.
Thank you, Your Honor. Mr. Crocker, just to reiterate for the record, you have reviewed the licensing and complaint files for Mr. John T. Hamblin, Jr. prior to your testimony today?
Yes, I have.
And has Mr. Hamblin ever held a Tennessee CPA license?
Yes, he has.
And what is his Tennessee CPA license number?
License number is 15371.
And was Mr. Hamblin's license issued on or about June 3rd, 1997?
Yes, it was.
And is Mr. Hamblin's Tennessee CPA license currently valid and in good standing?
No, it is not.
Is Mr. Hamblin's Tennessee CPA license currently expired?
Yes, it is.
And approximately what date did Mr. Hamblin's license expire?
His license expired December 31st, 2005.
Before we get to the current complaint, has Mr. Hamblin ever been disciplined by this board before?
Yes, he has.
And how many times has he been so disciplined?
Once.
And approximately when was Mr. Hamblin's prior discipline imposed against him?
July of 2002.
And for what violations was Mr. Hamblin disciplined?
Issuance of a substandard report and providing accounting services on an expired license.
Thank you. Mr. Crocker, I'd now like to show you a copy of a document and ask you to identify it for the record, please.
This is a copy of the consent order that Mr. Hamlin signed in July of 2002.
And is this document a true and correct copy of the consent order signed by Mr. Hamblin in July of 2002?
Yes, it is.
And can you ascertain what discipline was imposed against Mr. Hamblin pursuant to this consent order?
Mr. Hamlin was to obtain 16 hours of continuing professional education and compilation and review engagements. That was not to count toward his 80 hours that was required for renewal of his CPA license. There was a civil penalty in the amount of $1,000, and for a period of 2 years, the respondent was required to have the board perform a pre-issuance review on the first report that the respondent performs. The 2 years was to become effective upon execution of the consent order. He was to comply with all statutes and rules governing the practice of accountancy in the state, and I believe those are the applicable.
Thank you, Mr. Crocker. And is this document maintained in Mr. Hamblin's licensing and/or complaint files relative to this case in the ordinary course of business of the Accountancy Board?
Yes, it is.
Your Honor, I request that this consent order from July 2002, signed by the respondent, be admitted into evidence, and it is pre-marked as Exhibit 1 if Your Honor will admit the document.
It'll be marked and entered as Exhibit Number 1 and can be passed to members of the board. Do you have a copy of that? And I don't think we got the proof of service to be marked and entered.
Your Honor, are we referring to the green card?
Yeah, the one that was number 6.
That was published earlier. I'm not sure if the copy with the yellow exhibit sticker was handed to Your Honor.
It was not.
I believe Mr. Crocker has it.
Okay. Have the copy of this document with the exhibit sticker on it?
Mr. Crocker, can you just briefly explain for the record what the issuance of a substandard report means?
Issuance of a substandard report means that certain standards, professional standards, were not followed properly or adhered to during the course of the engagement.
And how could the issuance of a substandard report harm a CPA's client?
Depending on the nature of the violations, there could be loan covenants involved that perhaps were no longer being met due to the misstatements in the financial statements. It could affect stock price if it's a public company. It certainly could affect credit ratings. And of course, potential stockholders could be harmed if they are relying on misstated financial statements in order to invest in the company.
Thank you, Mr. Crocker. I'd like to turn your attention now to the present complaint for which we're here today. In approximately November of 2012, how did Mr. Hamblin come back to your attention?
He had a complaint filed against him by a client by the name of Mr. Becker.
And based on Mr. Becker's complaint filing, did the board in turn open a complaint against Mr. Hamblin on that basis?
Yes, we did.
And what were the allegations of Mr. Becker's complaint?
That Mr. Hamlin failed to timely file Mr. Becker's taxes and that he failed to respond to numerous attempts by Mr. Becker to communicate with him regarding his tax return.
Mr. Crocker, I'd like to show you another document at this time and ask you to identify it for the record, please.
This is a copy of the complaint filed with the Board of Accountancy by Mr. Becker.
Is this document a true and correct copy of the complaint filed by Mr. Becker against the respondent, John Hamblin, on November 27th, 2012?
Yes, it is.
And is this document maintained in Mr. Hamlin's complaint file relative to this case in the ordinary course of business of the Accountancy Board?
Yes, it is.
Your Honor, I request that this document be admitted into evidence and marked as Exhibit 2 with permission to publish to the board.
It will be so marked and entered and can be passed to the board.
We need to give the board members a minute to review this, or we keep going?
What would be your preference?
Thank you, Mr. Chairman. Mr. Crocker, I'd now like to show you a set of documents and ask you to review the set of documents for the record.
This is the notification to Mr. Hamlin that a complaint had been filed against him with the green card showing certified mail, showing that a Sarah Hamlin signed for it on December 11th, 2013.
So it's your testimony that it appears...
I'm sorry. It is December 11th, 2012.
Thank you, Mr. Crocker. Can you determine from the documents in front of you whether Mr. Hamlin received this letter from the board notifying him of the complaint?
As previously stated, the green card is signed by Sarah Hamlin, who is Mr. Hamlin's mother.
And was this letter sent to the previously referenced address at 8833 Sawyer Brown Road, Nashville, Tennessee 37221?
Yes, it was.
And is this set of documents maintained in Mr. Hamlin's complaint file relative to this case in the ordinary course of business of the Accountancy Board?
Yes, it is.
Thank you. Your Honor, I request that this set of documents be admitted into evidence, marked as Exhibit 3, and permission to publish to the board.
It will be so marked and entered and can be passed.
Mr. Crocker, according to your review of the complaint file prior to your testimony today, does it appear that Mr. Hamlin ever responded to this notice of complaint letter?
No, we did not.
And was Mr. Hamlin required by law to respond to that letter?
Yes, he is.
Thank you. Changing gears a little bit now, do the Tennessee Accountancy Act of 1998 located at TCA 62-1101 and subsequent sections and the rules promulgated thereunder primarily govern the conduct, of CPAs licensed in Tennessee by this board?
Yes, it does.
Just for the sake of brevity, so I don't have to say that 100 times, I'll refer to that as the law and the rules. How frequently do the law and rules require that a CPA holding a Tennessee CPA license require, how long is it required to renew his or her license?
Every other year.
And I believe you mentioned earlier that Mr. Hamlin's Tennessee CPA license expired on 12/31/05, is that correct?
Yes, that is correct.
And what does a Tennessee licensed CPA have to do to renew his or her license?
To renew timely, they must pay the fee of, back then it was $120 per renewal period, report CPE earned of 80 hours, broken down as specified by the rules.
And based upon your review of Mr. Hamlin's licensing file, at any time since 12/31/05, did the respondent ever make any attempt to renew his Tennessee CPA license?
No, sir, he did not.
So it's your testimony that for the 06/07, 08/09, 10/11, 12/13, and the current 14/15 renewal periods, the board has received nothing from Mr. Hamlin relative to a license renewal.
That is correct.
Is it a violation of the law and rules for a Tennessee licensed CPA to fail to timely renew his or her license?
Yes, it is.
So Mr. Hamlin's failure to timely renew his license for those renewal periods constitutes one or more violations of the law and rules?
Yes, it does.
And if a Tennessee licensed CPA does not wish to renew his or her license, is he or she required to notify the board of that intention and to surrender his or her certificate?
Yes.
And did Mr. Hamlin ever so notify the board of an intention not to renew his license?
No, he did not.
And that failure to notify the board constitutes a violation of the law and rules as well?
Yes, it does.
Did Mr. Hamlin ever surrender his CPA certificate to the board as required by the law and rules?
No, he did not.
And does his failure to surrender that certificate constitute a violation of the law and rules also?
Yes, it does.
Thank you. I'd like to show you another document at this time and ask you to identify it for the record, please.
This appears to be an affidavit created by Mr. Hamlin in response to the complaint dated May 17th, 2013.
And is this document maintained in Mr. Hamlin's complaint file relative to this case in the ordinary course of business of the Accountancy Board?
Yes, it is.
Your Honor, I request that this document, which has been pre-marked as Exhibit 4, be admitted into evidence with permission to publish to the board.
It will be so marked and entered and can be passed to the board.
And Mr. Crocker, I've got one more final set of documents for you to review and also ask you to identify this set of documents for the record.
This appears to be a letter sent to Mr. Hamlin in regard to settling this matter without a formal hearing. The letter outlines what the consent order would say.
And how was this letter sent?
This was sent via certified mail.
And can you determine from this set of documents whether Mr. Hamlin received this letter from the board notifying him of the potential of disposing of this matter without a formal hearing?
It appears the green card was signed by Sarah Hamlin.
And was that also at the previously referenced address of 8833 Sawyer Brown Road, Nashville 37211?
Yes, it was.
And are these documents maintained in Mr. Hamlin's complaint file relative to this case in the ordinary course of business of the Accountancy Board?
Yes, they are.
Your Honor, at this time, I request that this set of documents, pre-marked as Exhibit 5, be admitted into evidence with permission to publish to the board.
so marked and entered and can be passed.
One last question, Mr. Crocker. You previously referenced the allegations by the complaint in this matter, by the complainant, among which are failure to timely file client's tax returns, failure to return client records, and failure to communicate with the client regarding his engagement. If proven true, would those allegations constitute one or more violations of the law and rules?
Yes, they would.
Thank you, Mr. Crocker. Your Honor, I have no further questions for Mr. Crocker at this time.
Any questions from members of the board?
Your Honor, do we ask Mr. Whitaker the questions, or?
No, you fire away.
I just have one question, Mark.
Yes.
Looking
Gabe.
at the complaint, the handwritten complaint, the person says that the missing W-2 is from 2010, and they were trying to get an extension of 2010 taxes. But in the allegations of fact and the affidavit from Mr. Hamlin, it talks about the missing W-2 being from 2011 and 2011 taxes. Did we do some investigation to make sure which year it was that was late?
Your Honor, if I may, the board's investigator will be a witness in this matter. In fact, he'll be the state's next witness. He may be able to speak to that a little more specifically. And we also have the complainant in this matter here who will testify probably after Mr. Butler.
That's sufficient?
That's sufficient. Thank you,
Very
Your Honor.
good.
Thank you, Bill.
Crocker, did the respondent ever complete his required CPE in their consent order for 2002?
Yes, it appears that he did.
Civil penalty? that
He
was
did pay the
required?
civil penalty.
Thank
Yes.
you.
Mr. Crocker, it says in that original, or in 2002, that he practiced on an expired license. Do we know how long that expiration was prior to that?
Chairman, I don't have that information available.
Okay.
Any additional questions? Anything more for this witness?
Nothing, Your Honor.
Thank you, Mr. Crocker. You're excused. Your next witness?
State calls Ray Butler.
If you would raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. May I have a seat?
Mr. Butler, would you please state your name and position for the record?
My name is Ray Butler Jr. I'm a CPA and in the position of investigator with the Tennessee State Board of Accountancy.
And how long have you been an investigator for the board?
2.5 years.
Pursuant to your duties as board investigator, did you have occasion to become involved with and investigate this complaint against Mr. Hamlin?
Yes, I did.
Can you tell the board a little bit about that, please?
During the course of my investigation, I had numerous attempts of trying to locate Mr. Hamlin, going by his house, finding his vehicle there, knocking on the door. I had a discussion with his mom, or an older lady that I assumed to be his mom, telling her that I needed to talk with John. I called him on the telephone several times. I had found out some of his hangouts and drove by those numerous times because it's between here and my house. So I did that each time that I came into work and went back from work, and anytime I did any other complaints in the Nashville area, I always swung by his house and and all his hangouts to look for him.
And were you ultimately successful in meeting with the respondent and obtaining an affidavit from him?
Yes, I was.
And at this time, I'd like to show you a document which has previously been entered into evidence and marked as Exhibit 4, and ask you about that document. One moment, Your Honor, I'm going to grab a copy. Would you like to take a moment to review the affidavit, or?
I've read over it. This is the affidavit that I obtained on May 17, 2013.
Okay. And did Mr. Hamblin sign this affidavit in your presence?
Yes, he did.
And did you also sign this affidavit?
Yes, I did.
In this affidavit, does Mr. Hamblin admit to performing consulting services for clients even after the expiration date on his license?
Yes, he does, in the last sentence.
Okay. And does the performance of consulting services also constitute accounting services under the law and rules?
Yes, it does.
And is it a violation of the law and rules for a person to perform accounting services, including consulting services, without a valid current Tennessee CPA license?
Yes, it is.
And can you please provide a brief summary of your meeting with Mr. Hamblin for the record?
I met with Mr. Hamblin, sat down with him across from a table. We went over the facts of this particular case as to what the complaint was, and I asked him, since we'd never received a response, to write out his response to that complaint, which was in this Exhibit 4.
And so, just to reiterate, during that interview, you did explain to Mr. Hamblin the nature of the allegations against him?
Yes, I did.
And did he appear to fully understand the nature of this complaint?
He did.
According to your testimony, you met Mr. Hamblin in one of his hangouts. Does this hangout serve alcohol?
Yes, it does.
And did Mr. Hamblin appear to you to be intoxicated or otherwise under the influence of alcohol or other substances in any way?
No, he did not. In fact, I mentioned that I sat across the table from him. It wasn't apparent.
Okay. And in your own words, what was Mr. Hamblin's explanation for the allegations in the complaint, his provision of services with an expired license, and anything else that he wanted to add?
He really didn't have a reasonable explanation for not doing it. He just kind of went over the facts as had been presented by the complainant, and that was it. I mean, there was no, as far as I was concerned, no reasonable explanation for not doing the return or giving back the information.
And did Mr. Hamblin at that time indicate to you whether he intended to address, settle, or otherwise deal with this complaint beyond your meeting?
Not directly, but I did tell him that he needed to give the information back to the complainant as soon as possible.
Okay. And is there anything further that you would like to add for the record for the board to consider relative to Mr. Hamblin's complaint?
I would only say that as obvious by the fact that he didn't show up is that he's a very difficult person to get a hold of, and he cannot say that we didn't try to get a hold of him, because one of the things I didn't mention is I was also leaving notes on every time I saw his vehicle and he wouldn't answer the door, I was leaving notes on his vehicle that I needed to talk to him with my card.
Thank you, Mr. Butler. I have nothing further for this witness.
Questions from the board?
If you did know what he looked like, how would you recognize him in the pub?
I had a picture of him that I had gotten off the internet, and also when I went in to look for him, I asked the barmaid, told her I wanted to speak to John Hamlin, and she pointed him out.
Butler, in the complainant says that the W-2 that was missing was from 2010 and the extension was for the 2010 tax year. But in the allegations of fact and in the affidavit from Mr. Hamlin, it looks like the missing information was from 2011 and the taxes were for 2011. Can you explain that or just confirm that you investigated that piece of it and understand and confirm for us which year was in fact the one the taxes were not prepared for?
I saw that in the allegation, and I saw where when Mr. Becker wrote out his complaint, he first put in 1 year and then marked out another year. I'm not sure that I directly questioned those discrepancies in those dates. I will tell you, as a former practicing CPA, when you get down to extending something down to October, it gets kind of confusing which year you're doing. I mean, you extend it down to October 12 for October 11, and almost all the year of October 12 is over with. So, and you've probably already been working on some October 12, so it does get a little confusing as to which documents you've passed to somebody and hadn't had done yet, and on the accountant's part as well.
I guess I just want confirmation that the board knows which tax return wasn't filed, just to make sure we understand that in fact it was the 2011 tax return that was not filed timely, or if it was the 2010. I
think you were given a copy of the complaint, and I believe it said 2010. They said do my 2009 taxes in 2010. And then he had to get back to him for the 2010 because of the W-2 that was missing.
Okay. So my follow-up question is, in our allegations of fact, in page 2, I believe is where it is, perhaps page 3, it talks about getting an extension from 2000. The way I read it, I may be misreading it, but it looks like we're talking about a missing W-2 from 2011, and the extension was for the 2011 taxes. So I just want to resolve the confusion, and maybe it's my confusion. If so, I apologize to the board.
Roberts, if Mr. Butler is unable to resolve this discrepancy, we still have the complainant, Mr. Becker, with us today. And it looks like there is a little ambiguity in the complaint because of something crossed out. So perhaps direct questions put to him on that matter can resolve it.
More questions? Any further from the state?
Not for Mr. Butler, no.
Thank you, Mr. Butler. You're excused. Next witness.
Your Honor, the state calls Thomas Becker, the complainant in this matter.
Good morning, Mr. Becker. If you would raise your right hand for me. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. May I have a seat?
Becker, could you please state your full name for the record?
Thomas Scott Becker.
And what do you do for a living, Mr. Becker?
I'm a detailer reconditioner for Jim Kennedy Sales and Leasing.
Okay. And do you know John Hamblin, the respondent in this matter?
Yes, I do.
And how long have you known Mr. Hamblin?
Roughly 20 years.
And were you also a client of Mr. Hamblin in his capacity as a CPA?
Yes, I was.
Did you engage Mr. Hamblin at any time in the past to perform tax work for you?
Yes, my 09, he did my 09 and my 010. It was the 11 that I did not receive back.
I apologize for my own unclarity here. I just want to be as clear as I can for the record. So we'll take these one at a time. Did you engage Mr. Hamblin to perform your taxes or to file your taxes for the 2009 tax year?
Yes, I did.
And did you engage Mr. Hamblin to file your taxes for the 2010 tax year?
Yes, I did.
How about the 2011 tax year?
Yes, I did.
Okay. 2012 or any time thereafter?
No, sir.
Okay. During the years that Mr. Hamblin was your CPA and responsible for filing your taxes, did you provide all of the necessary documentation for Mr. Hamblin to file your taxes to him while he was engaged to file the taxes?
Yes, I did.
And to the best of your knowledge, did Mr. Hamblin timely file your taxes for the years in question?
Phrase that.
I will try. For your 2009 tax return, did Mr. Hamblin file your taxes?
Yes, he did.
How about 2010?
Yes, he did.
And 2011?
No, he did not.
Thank you. Relative to your 2011 taxes and tax return, did you attempt to contact Mr. Hamblin to ascertain the status of your tax returns and whether they've been filed?
Yes, I did.
And how did you attempt to contact Mr. Hamblin?
Telephone, going by his residence.
And approximately how many times would you say that you attempted to contact Mr. Hamblin regarding your 2011 taxes?
At least 10 or 15 times.
Did Mr. Hamblin ever respond to any of your numerous attempts to contact him regarding the status of your 2011 tax returns?
No.
Did Mr. Hamblin ever return your client records that you gave him in order to file your 2011 taxes?
No, he did not.
And did you ultimately have to retain another CPA at additional expense to file your 2011 taxes?
Yes, I did.
About how much did that replacement CPA run you? Just ballpark.
$150.
Okay. And as a result of the late filing and or non or never filed filing of your 2011 tax returns, did the IRS assess any fines against you for the untimely tax filing?
Yes, they did.
Do you have any idea how much that amount is? Again, ballpark is fine.
I do not.
And is it your understanding after speaking with the IRS that any such imposition of fines for later untimely filed returns may be deducted from a future tax refund?
Yes.
And have you contacted the IRS regarding your issue with Mr. Hamblin not filing your 2011 tax return on time?
Yes, I have.
And to the best of your knowledge, what is the status of the IRS's consideration of your request? Well, let me break this up into two pieces. When was the last time you spoke to the IRS regarding this matter?
I received a letter from them on, I believe, March 31st in regards to a form that I had given them in regards to this matter.
What document or documents did you file with the IRS?
It was a failure to prepare form.
And
I'm not sure what the number. I think Ray has the number there.
Okay, and is it your understanding that the IRS's consideration of your filing is still pending at this time?
Yes, it is.
Becker, is there anything else that you would like the board to know about your complaint against Mr. Hamlin?
I did speak with John shortly after Mr. Butler approached him in regards to this matter, in regards to getting my documentation back to me. And he did in so tell me that he would either mail it to me or bring it to my home, of which I never received anything. Never even spoke to him again.
So just to be clear, as we sit here today, Mr. Hamlin has not returned your records to you.
No, he is not.
And he has also not responded to or communicated with you in any way other than the one phone call you just referenced.
Correct.
Your Honor, that's all the questions I have of this witness.
Question from the board.
Mr. Becker, did Mr. Hamlin hold himself out as a CPA to you?
Yes, sir. I knew, like I said, I've known John for 20-something years, and I knew that he was a CPA, and he was recommended to me. So,
Do you recall if he signed your tax return
Yes,
for
sir, he did.
CPA at the
Yes,
end
sir.
of his name?
yes, sir, he did.
Mr. Becker, did you pay him for the 2009 and 2010 tax returns?
Yes, ma'am.
More questions? More questions from the state?
No, Your Honor, nothing further from this witness.
Thank you, Mr. Becker.
Thank you, Your Honor.
Additional witnesses?
No, Your Honor, that concludes the state's proof in this matter.
Closing statement?
Yes, Your Honor, just a very brief closing, and then I also have a proposed findings of fact and conclusions of law at the conclusion of the closing. Ladies and gentlemen of the board, you've heard the proof in this case today and is now concluded. The state submits to the board that it has proven the allegations against Mr. Hamlin as outlined in my opening statement and in the notice of hearing and charges, specifically that Mr. Hamlin was previously disciplined by this board for multiple violations, some of which we are here on again today, that Mr. Hamlin was practicing on an expired license that has been expired since the end of 2005, that he failed to timely renew his license, failed to surrender it, and or failed to notify the board of his intention not to renew or not to further practice accountancy. State submits that it is also proven that the respondent did in fact perform accounting services for the complainant in this matter, Thomas Becker, while his license was expired, and the state further submits that the respondent, Mr. Hamlin, failed to exercise due professional care and to competently perform services during this engagement by failing to timely or file at all Mr. Becker's 2011 taxes, and all of this failure to exercise due professional care and performance of services occurred on an expired license. The state's prayer for relief in this matter would be to impose a civil penalty in the amount of $5,500 for these various violations, and also to revoke Mr. Hamlin's Tennessee CPA license. That concludes the state's closing statement in this matter, Your Honor.
Would the members of the board like to proceed with the charge and the deliberations, or take maybe a 10-minute break before doing so?
I would prefer to move forward if we can.
That's fine with me, if that's okay with the board. Okay with you? Very well. If you would pass out the proposed findings of fact and conclusions of law to the members of the board. This case will now be submitted to the board for deliberation. You must decide this case from the evidence which was presented at the hearing. This evidence consists of sworn testimony and exhibits. The state has alleged that the respondent has violated certain state statutes and rules. The state has the burden of proof in this matter. The respondent does not have the burden of proving that he is innocent of the charges. It is the state's burden to prove its allegations by a preponderance of the evidence, which means the greater weight of the evidence is in favor of the state. Statements of counsel made during the course of the proceedings are not to be considered as evidence to satisfy the burden of proof. The Administrative Procedures Act specifically requires your order to contain 4 sections: findings of fact, conclusions of law, a decision regarding the appropriate relief, if any, and the policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and any documentary evidence admitted. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. The notice of charges and the proposed findings of fact are not evidence. You may use either or both of these documents as guides to assist you in making your findings, but it is the sole responsibility of the board to make your own findings of fact. You should use the documents as guides only after careful consideration and a determination that the notice and proposed findings accurately reflect your own independent recollection of the evidence and your own conclusions. Once you have made your findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges. And if so, you must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate linkages and connections between the 2 sections of your final order. You must limit your inquiry regarding the violations of statutes and rules to those violations alleged in the state's notice of charges. If you decide that there has been a violation of a state statute or rule, you must then decide whether the relief requested by the state is appropriate in accordance with the legal authority and considering the particular circumstances of this case. You may grant the state's requested relief or decide that some other relief or none at all is more appropriate. Finally, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason tells the public and reviewing courts why the action you choose in this case is proper. The gravity of the violation and the respondent's attitude towards the action may be included in your policy statement to support your decision. The decision should be more than just a reiteration of the facts you have found in this case, but should be a short statement as to why the action you have chosen is correct. If you need assistance with the law or the structure of your order, I will be available to assist you. If you have any questions about the facts presented, you may, by a majority vote, go back on the record and hear from counsel or witnesses to refresh your memory. All motions must be carried by a simple majority of the board. I will now turn the matter over to the chairman to preside over the deliberations.
All right, does anybody have any commentary they'd like to share?
I have a
question regarding the penalty amount, if this is the proper time, or if you want to address that in the penalty phase.
We can address that now.
Why, can you help me with how the penalty was derived? Potential of $0 to $12,000 in penalties, and the second time around to $5,500, which seems light. Could you-
In order to hear from council, you'll have to suspend deliberations by majority vote.
Or do you
And-
just want to address we can address the actual penalty?
The court reporter needs just 1 second. She ran out of tape. But the penalty is a recommendation from the department, and you can make your own calculations and determine what you could determine to be an appropriate penalty.
Thank you, but to get the thought behind that penalty, we would have to suspend, is what I'm hearing you say.
That is correct. And then you may want to do that from council or.
I'm happy to suspend deliberations for the moment to allow the question to be answered.
And would you like to hear from council? Would you like to hear from Mr. Crocker?
Council, I think, has probably made the recommendation with the input from Mr. Crocker.
Okay, and you'll need to do that by majority vote of the board members.
Okay. All those in favor of suspending deliberation, please signify by saying aye.
Aye.
Okay. Any noes? None. Okay. We're suspended.
Very good. Mr. Whitaker?
Thank you, Mr. Royston. Just a brief summary. I counted, as I believe the proof covered, 5 separate reporting periods for which the respondent failed to timely renew his license. I calculated a $500 civil penalty for each of those, for a total of $2,500 for the aggregate failures to timely renew, and then the maximum $1,000 apiece for the respondent's failure to file the tax returns, timely or otherwise, $1,000 for Mr. Hamblin's failure to communicate with his now former client relative to the status of his tax return, and then another $1,000 for the failure to return client records as required. As is generally the case, and as Your Honor just mentioned, these are recommendations, and the board is always free to amend them as they see fit. But basically, I felt like I had to come up with a number for a recommendation to start the board's thought process and to give you all something to work from. But I'm happy for the board to do its will, provided that it matches up with its ability to do so in the law and rules.
What are the civil penalties that have been assessed in the past?
Typically for,
Excuse me, I'm referring to this particular person.
for this particular person, the civil penalty in Mr. Hamlin's 2002 consent order was $1,000. This proposed civil penalty would be $5,500, which is, by my math, a 550% increase over the last go-round. And the state is also requesting the revocation of Mr. Hamblin's license in light of his repeated failure to comply with the board's law and rules, to maintain his license appropriately, and whether or not he maintained his license in the prior consent order or now, it appears he also has an issue with competence in performing quality work. So the state's position is that that constitutes a danger to the public, and as such, that Mr. Hamblin's CPA license should be revoked in addition to the imposition of the civil penalty referenced.
Can I ask a question? You mentioned there were in your calculating this proposed penalty, it was 5 reporting periods times $500. What were the 5 periods?
Well, according to Mr. Crocker's testimony, Mr. Hamblin was last validly currently licensed effective 12/31/05, and since he ends in Mr. Hamblin's license is due up for renewal in odd numbered years, I counted 06/07, 08/09, 10/11, 12/13, and the current period as we sit here today for 14 and 15.
Other questions? Your Honor, can we return back to deliberation?
By majority vote.
Okay. All those in favor of returning to deliberations, please signify by, I'm sorry, I guess I need to have a motion.
Motion to return to deliberation.
Second.
Okay. I have a motion, I have a second. Any comments? All those in favor signify by saying aye.
Aye.
Any noes? Hearing none, we're back in deliberations. Does anybody want to entertain a motion to accept the findings and facts as proposed, to at least start the process of whether or not we agree with the attorney's proposed findings of fact, and we can get that piece done and then discuss penalties?
I'm sorry.
I just had one comment on item 9, or item 9 of the proposed findings. It mentions that respondent, he'd allowed the respondent to do his federal income taxes since 2010, which is the 2009 tax year. Shouldn't that be 2011 tax year?
Now, the allegation
I think it says-
indicated that he did the return for 2009, 2010, and failed to do the return for 2011.
It should say the 2010 tax year in parentheses.
This is 2009 tax year. He did, oh, wait. I
He
think-
performed the services in 2010 for the 2009 tax year.
But he also did
Forward.
2010 tax year as well. As you're saying, forward?
It says
Since, okay, since.
since, and
Okay.
then he failed on the 11 return.
Okay.
Right.
Right.
Mr. Chairman, if the board would go through each of the factual allegations and specifically address them and adopt them, you can discuss them in total and then adopt them in total by motion or individually, but it helps for purposes of deliberation and judicial review, should that be necessary for there to be deliberation on each factual allegation.
Hear any motions?
Chairman, I move that we accept proposed findings of facts number 1 and 2 as presented by Mr. Whitaker.
Motion, do I have a second?
Second.
Okay, any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Okay, the proposed findings of fact are approved, or accepted.
I hate to be tedious, but if we could have them specifically
Do
addressed.
roll call. Oh,
I'm
you want
sorry.
to do 1 and 2?
No, if they could be specifically read into the record as the finding that's being adopted. I know it can be tedious, but the Court of Appeals has found that actual deliberation on the facts is necessary in order to uphold the order, should it be appealed.
Want to restate your motion?
Mr. Chair, I'd be glad to. Mr. Chairman, I make the motion that proposed finding of fact number 1, which reads, the Department of Commerce and Insurance, Division of Regulatory Boards, the state, is the lawful agent through which the act is enforced, and the state is authorized to bring this action, be accepted as presented.
I have a motion, I have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
Chairman, I'd also make the motion that this board find proposed finding of fact number 2, which reads as follows. Respondent holds certified public accountant CPA license number 15371, issued by this board on June 3rd, 1997, which expired on December 31st, 2005. Respondent also holds a CPA firm permit number 2879, issued by this board on July 18th, 2002, which expired on December 31st, 2004. According to the books and records of the board, the respondent's last known address is 8333 Sawyer Brown Road, Nashville, Tennessee 37221. Mr. Chairman, I propose that we accept this proposed finding of fact.
I have a motion. Do I have a second?
Second.
I have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
Your Honor, if I may, just briefly for one moment.
Not during deliberations.
Okay.
Your Honor, may I ask a question to you?
Certainly.
Would this, if we adopted this entire without reading through it, would this not be part of the record that the Court of Appeals or whoever may be able to read and review?
This document is not necessarily a part of the
Okay.
record. No, this document is provided to you as a guide to inform your deliberations, but not to be the actual document this is not the order, and it's not evidence.
Okay.
It's merely presented to you as a guide for
Great.
your deliberations.
Thank you for clarifying that, Your Honor.
Mr. Roberts, you want to carry us on through?
I'll be glad to, Mr. Chairman. Mr. Chairman, I make the motion that allegation of fact number 3 be accepted as presented by Mr. Whitaker. For the record, I will read allegation 3 as it's presented. It says the respondent has failed to timely renew his Tennessee CPA license and his Tennessee CPA firm permit, or to notify the board that he no longer desires to renew the license and permit. Further, respondent has failed to surrender the license and permit to the board upon their expiration as required. I would move that we accept this allegation of fact.
Have a motion. Do I have a second?
Second.
Any discussion?
Is it possible for Mr. Roberts just to go ahead and read all of the
Can he read and
allegations
vote
take
one
care
time?
of
That would be acceptable.
Okay.
Yes.
May I amend my motion, Mr.
You
Chair?
may.
I would also move that this board accept the remainder of the allegations of fact, which I will read in number as follows. Number 4, during early 2012, the respondent agreed to complete client Thomas S. Becker's 2011 federal tax return. By the middle of March 2012, Mr. Becker had provided respondent with all of his tax information and documentation except for one missing W-2 for the 2011 tax year. Mr. Becker asked respondent to file an extension request with the IRS by April 15, 2012 for his 2011 tax return, but never knew whether respondent did so. Number 5, Mr. Becker located the missing W-2 later in 2012, enclosed it within an envelope, and left it in respondent's residential mailbox on or about September 15, 2012, and expected respondent to prepare and file his 2011 return by October 15, 2012. Prior to delivering the W-2 in this fashion, Mr. Becker had left respondent phone messages several times requesting to meet respondent at some restaurant or other public location in the Bellevue area of Nashville to deliver the W-2. Respondent did not respond to these messages or return Mr. Becker's calls. Number 6, respondent did not file this client's 2011 federal income tax return by October 15, 2012, and did not respond to many additional voicemail messages left by this client since October 2012 requesting a status report on the tax return and the return of the client's documentation. Respondent has failed to furnish to this client all of the client's 2011 tax records through the present. Number 7, Mr. Becker submitted a complaint against the respondent regarding this matter with the board's staff in December 2012, and the staff forwarded respondent a copy of this complaint by certified mail correspondence dated December 10, 2012. This letter and enclosed complaint were received on December 11, 2012, but respondent failed to file a written answer within 14 days of receipt as required. Respondent did not request and was not granted an extension of time to answer this complaint. Number 8, after being found in a Bellevue pub by a board investigator on May 17, 2013, respondent admitted that he had performed tax work for Mr. Becker and also admitted that he currently did monthly bookkeeping and consulting services for small businesses. Such action constitutes the provision of, quote, accounting services under the rules of this board and the respondent's performance of such services on an expired CPA license and an expired CPA firm permit constitutes unlicensed conduct in violation of applicable authority. Number 9, Mr. Becker has known respondent for nearly 20 years and has allowed respondent to do his federal income taxes since 2010, the 2009 tax year, upon respondent's statement that he was able to do tax preparation work. The only manner in which Mr. Becker has been able to transact tax business with respondent over the past several years in person has been to meet respondent at neighborhood restaurants or other businesses. And number 10, the respondent has been disciplined previously by this board, having been assessed a civil penalty of $1,000 for issuing a substandard audit report and a 2002 consent order entered in case number L01-ACC-RBS-2001-030911.
I have a very lengthy motion. Do I have a second?
Second.
Okay. Any discussion? All those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the ayes have it.
If in reviewing the, looks like there's a section of applicable law and then the causes of action, which would provide the linkages for you between the findings of fact and the laws as stated.
You want that read in as well?
I'm sorry?
Do you want that read in as well?
The statutes and regulations?
Yeah.
No, you just
Okay.
need to do, I think, the causes of action, which would be your conclusions of law that start on page 8.
So we have moved for all of these, or acceptance of all these conclusions. I guess we need to move it, is it penalty? Is that what you're,
No, you'll need to, based upon those findings of fact, you'll now need to determine, based upon those facts,
that we in fact have violations?
correct.
Okay. Is there any discussion on these matters at all? Are we ready to move into that particular motion? Okay. I have a motion.
Mr. Chairman, I would move that based on the findings of fact that we do have the violation, we do have violations of the applicable law and rules, and would make that motion before the board.
A motion, do I have a second?
Second.
Any discussion? Hearing none, those in favor signify by saying aye.
Aye.
Any noes? Hearing none, motion passes. Penalty.
Well, you'll need to determine what laws have been violated based upon, say, this fact means a violation of this law, which I think is basically what's been done in your causes of action. But you'll need to specifically deliberate on each violation and then determine, based upon that violation, how much you think the resulting penalty should be.
That be by, Your Honor, under the sections using chapter definitions, or do we need to go into the subsections and read them in so that the court record is clear on what we're saying? For instance, under chapter definitions, we found that under 62103, he did hold himself as being a CPA.
Well,
Or do we need to delineate each line item?
you can go through the causes of action, which start on page 8, and adopt those if that's your preference, which does have references to all of the applicable statutes and regulations, or you can go through the applicable statutes and regulations. And for instance, let's see.
Your Honor, may I make one comment? I don't mean to interrupt you, but I think I may have some, Your Honor is speaking about actually page 8 of the notice of hearing and charges, I believe. Is
No,
what
I think it's the, oh, you're right, I'm sorry, I apologize. Which is, yeah, because that's missing from your proposed. Yeah, I think it is probably laid out a little bit better for you in the notice of hearing and charges.
So, Your Honor, should we read the causes of action from the notice of hearing to show that we've deliberated on these causes of action?
I think it probably would be helpful if you read one at a time and maybe had some deliberation on them. And you will certainly need to do so in order to determine the appropriate penalty.
Mr. Chairman, may I make a motion, please?
You certainly may.
I would make a motion that this board finds this following cause of action to exist. And I'll read the cause of action. Count 1, respondent's acts and conduct in failing to immediately surrender his expired CPA firm permit and his expired CPA license to this board after their expiration in 2004 and 2005, and his failure to notify the board of his intention prior to the expiration of those licenses as described in numbered paragraphs 2 through 3 of the foregoing allegations of fact, constitute violations of Tennessee Code Annotated Section 62-1-111, Section A3 and 6, and Tennessee Comp Rules and Regs 0020-01-082 and 0020-03-.121, subjecting respondent to the imposition of possible revocation or suspension of both his CPA license and his firm permit, and civil penalties in the maximum amount of $1,000 per day for each day of continued violation, and the assessment of investigatory and hearing costs pursuant to Tennessee Code Annotated Sections 56-1-308A, 56-1-311A, and 10 Comp Rules and Regs 0020-04-.021 and 2, and 0780-5-11-.011.
I have a motion. Do I have a second? Any discussion? Hearing none, all those in favor of the motion, please signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
If I may make a suggestion, it may be easiest for the board to discuss penalty after you do each one of the violations rather than having to go back and redeliberate after you've gone through.
I recommend a penalty on count 1 of $2,500. Or I have a motion for a penalty for $2,500 on count 1.
I would second that, Mr. Chairman.
Have a motion, have a second. Any discussion? Hearing none, all those in favor of the penalty signify by saying aye.
Aye.
Any opposed?
I'm sorry, if I may, based upon the language, it says in the maximum amount of $1,000 per day. So if you would specify your rationale behind the proposed penalty.
Mr. Alexander, may I make a friendly amendment to your motion?
Please.
I would ask that, the rationale for the $2,500 penalty that I believe you had recommended would be based on $500 per period, I believe, for 5 periods in which these licenses were not renewed timely.
Per reporting period.
Per reporting period.
Yes, that's correct.
And I'm sorry, I would have to just point out to the board that you're limited to considering any factual allegations that are contained in the notice of hearing and charges, which is dated December 17th, 2013. So you wouldn't be able to consider anything that occurred after that time period.
Our $2,500 is still within the framework of what's allowed.
I believe she's referring to that the 13-14 year wasn't,
Or the 14,
14-15 year, excuse me, thank you, was not delinquent yet.
Amended $2,000, sure.
Well, now, is this, realizing that, and I think that this is just a penalty for him individually, and there's a firm permit that I'm not sure was in the allegations, except that it's mentioned that he did not renew that either when we're looking at our penalties. Not only looking at his individual license, but a firm permit that was not maintained.
I would like to amend my motion to $2,000 in recognition that there are only 4 reporting periods because of the December 13th cutoff.
I would second that amendment.
Thank you. Any discussion? Hearing none, all those in favor of the $2,000 penalty, please signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
Chairman, I'd like to also make a motion for a cause of action, a second cause of action, if I may read it into the record. Count 2, respondent's acts and conduct in performing accounting services in the form of tax preparation and business consulting, while his CPA license and CPA firm permit were both expired as described in numbered paragraphs 4 through 6 and 8 through 9 of the foregoing allegations of fact, constitute violations of Tennessee Code annotated sections 62-1-111A6 and Tennessee Comp Rules and Regs 0020-01-.111, subjecting respondent to the imposition of possible revocation or suspension of both his CPA license and his firm permit and civil penalties in the maximum amount of $1,000 per day for each day of continued violation, and the assessment of investigatory and hearing costs pursuant to Tennessee Code annotated sections 56-1-308A, 56-1-311A, and Tennessee Comp Rules and Regs 0020-04-.021 and 2 and 0780-5-11.011.
I have a motion. Do I have a second?
Second.
Any discussion? Hearing none, the motion carries. I guess we need to deliberate penalty. Do I have a motion for penalty on this particular cause of action?
Make a motion for a penalty of $1,000.
Second.
Do we need a rationale for that, Your Honor?
Well, the rationale is that the penalty, we're allowed to penalize him up to $1,000 per day, so we think that's well within the guidelines presented. Is that acceptable?
But $1,000 would be based upon what conduct?
Count 2 that was just read.
Well, I'm so, how is the $1,000 being assessed specifically? If it's $1,000 a day and the penalty is $1,000, how is that being, what is the dollar amount that is, what conduct is the dollar amount being assessed to? Because you have acts of tax preparation and $1,000 penalty.
How about for the year that he admitted that he was providing accounting and consulting services for clients? When
I'm not sure how to respond to the question, quite frankly.
Help the board.
Mr. Roberts, could you help us out perhaps since you're an attorney?
Mr. Alexander, I'm actually going through that right now. Go buy me just a little more time. We'll,
How about for the admission of providing accounting and consulting in his affidavit? I know that's not perfect, but
Your Honor, if I'm reading this correctly, we just discovered, or you reminded us correctly, that there are 4 reporting periods that we're limited to assessing damages against based on the date of the notice of hearing. Is that correct?
Yes.
So we're talking about providing services in tax preparation and business consulting that were admitted to in the affidavit for a period of 4 years. I think $250 a year for those 4 years would be reasonable, given that the maximum is $1,000 per day, and that could be fairly steep. 365 days a year times however many years are in each period times the number of periods. In an effort of restraint and reason, I would say $250 per period, for the 4 periods that we can assess damages against would be a reasonable way to assess a damage here. So I would make the motion that we're going to assess $1,000 penalty for this count.
Does he have to rescind his motion?
I'll withdraw my motion.
Thank you.
Thank you.
Mr. Chair, I'd make the motion that we assess $1,000 penalty for the count 2 on the basis that for 4 periods during which this action was ongoing, we would be, in an exercise of restraint, only assess $250 per period for a total of $1,000.
Second.
Motion, I have a second. Do I have any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion passes.
Mr. Chairman, I'd like to make another motion, please, as a cause of action, count 3 that I'll read into the record. Respondent's acts and conduct in failing to return to Mr. Becker as his client, all tax documentation for the 2011 tax year provided to him by Mr. Becker within a reasonable time, as requested by Mr. Becker and as described in numbered paragraph 6 of the foregoing allegations of fact, constitute violations of Tennessee Code annotated sections 62-1-111A6 and 7 and Tennessee Comp Rules and Regs 0020-03-.111A, subjecting respondent to the imposition of possible revocation or suspension of both his CPA license and his firm permit, and civil penalties in the maximum amount of $1,000 per day for each day of continued violation, and the assessment of investigatory and hearing costs pursuant to Tennessee Code annotated sections 56-1308A, 56-1-311A, and Tennessee Comp Rules and Regs 0020-04-.021 and 2 and 0780-5-11-.011.
I have a motion. Do I have a second?
Second.
I have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries. Consider penalties for this particular count.
Mr. Chairman, I'd make a motion that we assess a penalty for this count of $1,000 for failure to return records.
That is a one-time event. Okay. You good with that, Your Honor? Okay. I have a motion on the floor for a $1,000 penalty. Do I have a second?
Second.
Any discussion? Hearing none, I'm sorry, yeah, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
Mr. Chairman, I'd like to make an additional motion, please, as cause of action count 4 that I'll read into the record. Respondent's acts and conduct in failing to file a written answer with the board to the complaint of Mr. Becker within 14 days after he received said complaint, where no extension of time to answer was granted to respondent as described in numbered paragraph 7 of the foregoing allegations of fact, constitute violations of Tennessee Code annotated sections 62-1-111A6 and 7 and Tennessee Comp Rules and Regs 0020-03-.163, subjecting respondent to the imposition of possible revocation or suspension of both his CPA license and his firm permit, and civil penalties in the maximum amount of $1,000 per day for each day of continued violation, and the assessment of investigatory and hearing costs pursuant to Tennessee Code annotated sections 56-1-308A, 56-1-311A, and Tennessee Comp Rules and Regs 0020-04-.021 and 2 and 0780-5-11.011.
I Have a motion. Do I have a second?
Second.
Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries. Okay, I'll accept a motion on penalty.
Move to assess a penalty of $1,000 based on his one-time event of his failure to respond to the board's.
Can I make one comment?
Sure.
The recommended penalty was $5,500. I think we're at $4,000. Just as a,
We reduced
Comment.
it $500 because of that one reporting
Oh.
period that we backed out for 14 and 15. I think that
okay.
was.
Just want to make sure.
Mr. Chairman, also remind the board that the other recommendation of penalty was a revocation of respondent CBA license.
We can come up with our own penalty amount,
Right.
too.
Absolutely. I'm just pointing out what was recommended.
I'd also like to ask the question, how do we go about assessing the hearing cost, the investigation cost? Is that automatically added on, or does it,
You vote on that as well.
we have to vote on that
Yes.
as well? Okay.
Your Honor, does it need to be tied to one of these causes of action, or is that something we can deal with after the fact?
The civil penalties was easiest done with respect to the counts, that you can have an easy mechanism for justifying the amount of the penalty. I think the other recommended penalties, the revocation and the costs are easily done in total. Just based upon all of the findings of fact, we believe that revocation or suspension or whatever.
Thank you.
So I have a motion on the floor for a $1,000 penalty.
I'll second that.
You have a second? Okay, I have a second for that. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
Chairman, I'd also like to make a motion that we assess investigation cost and hearing cost for this particular event.
Could that motion include revocation of his license?
We can make that,
Does it?
or we could do it separately, either one.
Why don't we do them together if the judge, or if Your Honor has no objection?
That'd be fine. I would make a motion that we revoke his license also.
I have a motion for hearing cost and for revocation of license. Do I have a second?
Second, subject to a friendly amendment.
Okay.
The revocation should be, as stated, for the period of 5 years.
Fine.
Okay, I have a second with a revised amendment there. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries. Okay, Your Honor, I believe,
Have your policy statement.
okay, I'm going to attempt this. It is this board's purpose to protect the public. This board agrees and accepts the proposed findings of facts and conclusions, and that Mr. Hamlin did, in fact, violate the rules and regulations of this board. As such, this board has assessed the penalties that have previously been agreed to and all hearing cost and revocation of Mr. Hamlin's license due to the violation of the rules and regs of this board.
Motion.
Oh, it's a motion.
I second that motion, Mr. Chairman.
Thank you. Any discussion?
I would like to say I do think this is a serious matter. I think that the public interest is absolutely well served in making sure that the board protects our profession and the profession of accountancy.
Absolutely. Any other discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, the motion carries.
I believe that concludes the contested case hearing for this morning. Is there anything further from any member of the board? It's my job. Thank you all so very much. The contested case hearing is hereby adjourned.
Thank you.
Thank you.
You're excused. You've earned your absence.
I think we could take a break at this point.
Yeah. Do y'all want to take a short break or a?
Short.
Okay.
Go on the record. No, you can't. I greatly apologize, but I need you to step out at this time.
That's fine.
Thank you.
I appreciate your help.
We're glad you were here till now.
Absolutely.
Yeah, I think we'll let you read in anytime you want.
I want to move into the licensing committee. Mr. Eldridge, if you could.
Thank you. I'm going to go out of order on the agenda. One of our issues, review of policy statements regarding non-registered CPE sponsors. I believe Mr. Goodman's here with us, so out of respect for his time, I'll go ahead and take that one first. Yesterday, let's see. Let me get my notes. This is a review of policy statement regarding non-registered CPE sponsors. We had a request by Mr. Joe Goodman, I believe that's correct, to consider our policies. Mr. Goodman had some CPE that he had taken that was not, but I guess he had completed, that was not sponsored by either NASBA or the Tennessee Registry, and was determined to be ineligible. And I believe there were three courses. One was with the IRS, which is an exempt organization, and then two others that were non-exempt or non-approved CPE providers. We've got two items, I guess, to talk about. The first thing, the committee discussed this and understands Mr. Goodman's points, but based on Section 0205-.04, Item 9, which states, in order to ensure credit, any program of continuing education not specifically covered by this rule must be submitted to the board for evaluation before attendance and/or completion. And based on the information that was provided to us, the requests for approval were submitted subsequent to his completion of these courses. So based on that law, the committee recommends to the board that we denied this request. I guess the second item related to this was, excuse me, there was a request. The request was for us to review our policies and procedures and rules for the requirement that non-exempt sponsors register with NASBA, the requirement for prior approval of a non-registered sponsor, and the limit of one exemption per reporting period. The committee would like to just ask the board if the board would like to consider discussing and possibly changing those rules and policies.
Mr. Whitaker, I'm not sure of the procedure here. We've got recommendations, but knowing that we have someone here to comment, I guess, is it okay for him just to go ahead and make his commentary before we deliberate these actions?
I think that's fine. If the board wishes to consider Mr. Goodman's comments as part of its deliberation, then it's probably preferable that he go first and get what he has to say before you, and then the board can have that information as it discusses this matter.
Mr. Goodman, if you would.
Thank you for your consideration. I'm very relieved to know that the judge and stenographer and lawyers were not for my benefit. And I am asking for consideration of a broader matter. By way of reference, I have been a tax lawyer, estate planning, wealth planning, family business planning, mostly in the context of a law firm, boutique firm typically, small concentration of tax lawyers. I have practiced previously in a large CPA firm. I've been doing this for 35 years, almost exclusively. I have some degree of notoriety for doing it fairly well, have a nice clientele, and I'm very proud to be a holder of a CPA license on an active basis. I'm proud of my PFS credentials, which I've had for a good number of years. I am a numbers person, and I'm faced with losing my CPA license and my PFS designation unless I go through some hoops that I believe are unreasonable and unnecessary for purposes of making sure that I am qualified to carry the CPA license and PFS designation. And before I go and leave the fraternity of CPAs, I appeal the decision from Ms. Conlon and whoever to say that the board can pass any rule it wants to with respect to CPE requirements. I observe that the enabling legislation certainly delegates that authority to this board, and properly so. I can take issue with the fact you've delegated it in toto to the TSCPA and the NASBA to allow them to construct a system for continuing professional education that you deem to be almost exclusively appropriate for my education. And the few others who are in my boat who may be attorneys and CPA dual holders and other multiple certificate holdings. Yes, I could buy tapes and online videos in the TSCPA. Last year they offered 4 live tax conferences, which didn't help me any. They offered almost 200 online videos for purchase in tax and management technical specialties. If I cared to purchase them and carry them to my office and turn on the reel and I guess whatever I would do meanwhile, I'm old-fashioned. I like to attend CPE conferences. I like to spend the half day or full day absorbing the material, hundreds of pages usually, and to listen and have the dialogue and really learn the material live. I'm sorry, but I'm just old school. And I think what we're finding now with the CPE offered through this board, that it's been delegated to become a money-making machine for the TSCPA and the NASBA, which deprives me of a reasonable opportunity to maintain my education. My education requires a high level of pretty complicated current events. The American College of Trust and Estate Council, of which I'm a proud fellow and member, I'm on committees and subcommittees. When we have education programs, we think we're at the leading edge of what the tax laws are, what they should be, and what they will be at a national level and sometimes a state level. I think we do a pretty good job of maintaining educational standards and requirements appropriate for tax accountants, lawyers, estate planners, financial planners, wealth planners, family business advisors. And I'm convinced and fearful, you hear me shaking, it's not like me, to realize that I'm about to lose access to something that's a valuable and appreciated asset that I'm very sorry I'm going to have to lose unless, for example, I choose to go to the AICPA Advanced Estate Planning Conference in Las Vegas the 3rd week of July, spend $4,000, which I'll recoup through my gambling winnings, and to attend 2 days of certified, qualified conferences at a pretty high level, honestly, of which about half is relative to my needs for education and current education, etc. There's a few others I could attend, I guess. No, I'm not going to attend the Walter Nunnally annual How to Prepare a Tax Return that is sponsored by TSCPA. I don't need it, don't want it. I don't prepare tax returns on a regular basis. I don't do tax compliance. I do a few tax returns with big numbers in funny places, but they're rare. But I just enjoy being a CPA. I'm proud of it. And plus, I'm going to lose my PFS designation, which I think I've earned and I think I'm entitled to keep. I passed it pretty quickly without studying, and I had practiced a CPA for 20 years before that. I just think I'm qualified. Thank you. And I'm asking the board to overrule the administrative determination that, I'm sorry, this board has the right under law to pass any rules and requirements it cares to relative to CPE qualification and requirements. And we have the rule, and so be it. Good luck. Now, why do I not submit advance requests for approval? ACTEC and many of my conferences with American attorneys for family help, a lot of associations I'm in, do not choose to register with NASBA. There's too few of us weirdos who need it, and they say, I'm sorry, we're not going to pay $1,000, $2,000, $3,000, $4,000, $5,000 to register with NASBA, subject ourselves to the 14-page standards of excellence that are imposed by the NASBA and transferred to every sponsor approved by the NASBA. They won't do it. They also have to worry about the state-by-state unique requirements. You go to the Tennessee Federal Tax Institute, there's 5 tables of state-by-state forms already. An administrative nightmare. And ACTEC and FFI and the things I run around it say, we're not going to fool with that. Now, it's not snobbish, it's just there's too few of us, Lee Griffith, David Parker, who are trying to be dual as attorneys, and they just can't do it, they won't do it. When I go to these conferences in advance, and I'm going to them, I don't know if they're going to qualify, in my judgment, to be worthy to ask for acceptance as qualified continuing professional education. I just don't know. Some are and some aren't. Half are, half aren't. I can't fill out this monstrous imposing form that asks for CPE provider information, all the details, contact person, telephone number, et cetera, et cetera, et cetera. Give a summary of each session you plan to attend on a separate piece of paper. Attach a statement how this course relates to your practice of public accountancy, and describe how it contributes to the professional and technical competence of a CPA in public practice. I can't fill this out in advance until I go and determine which of these presentations, either as a presenter or as an attendee, that I can submit it in good faith and ask for your consideration. On the other hand, we have the NASB. I received these 2 in the last week from the NBI, who, I'm sorry, they're not well thought of in our circles. And I could attend this 2-day probate boot camp, paid $575.
Or can I interrupt just for 1 second?
Who's saying that? I don't know who's speaking.
The chairman.
Yes.
Can you just get more to the point of what you're asking of this board and less commentary, I guess, on other organizations offering CPE or accreditation? What do you want from this board?
I would like for you to consider modification of the rules and requirements to accommodate disabled and handicapped CPAs like me who don't fit into the model of practicing in a CPA firm that can conveniently and easily comply with your rules and requirements, and ask for another route, another way for people like me to receive and earn credit without going through the NASBA or TSCPA. That is my request.
Thank you for your time.
Thank you.
All right. Mr. Eldridge, do you want to continue?
Yeah, back to the original, our discussion, obviously, we had two issues we pointed out, was the first one being the request to approve the two submitted CPE courses, and the committee's recommendation was based on the current rules, that the request would be denied based on the current rules. Do I need a 02-05-.04, item 9, and that was our recommendation.
To have a recommendation from the committee to deny the credit. So that is a motion from the committee, I assume. Do I have a second for that motion?
Second.
I have a second from Mr. Haas. Any discussion? Hearing none, those in favor of adopting the committee's request or motion, please signify by saying aye. Aye. All those opposed? Hearing no opposition, the motion passes.
The other issue, I guess, related to this would correspond to Mr. Goodman's request for our committee to consider amending our rules or amending our laws to make different accommodations for non-registered CPE. Committee doesn't have a recommendation. It was just something we would discuss as a board. So
I'll open the discussion up here. I think it's a slippery slope when we start allowing people to dictate what CPE is required to maintain their certifications without our input. And I think Mark said it best yesterday in the committee hearings that, you know, we're putting people at risk if they think they're going to a conference which is going to qualify for CPE and they find out later that it's not an approved course. And I think it's a very dangerous position for our profession to be in, quite frankly. But I'd love to hear other commentary from the board.
I think I can appreciate Mr. Goodman's frustration with the fact that NASBA seems to be very expensive in some situations. But I will note that there are a lot of other means in here. You can subscribe to a journal, reading it, get credit from taking those. You can do continuing education. You can audit courses. There's a lot of other opportunities that do not involve NASBA or even the TSCPA that are listed in our current laws. So.
I'd have to concur with that and note that it's our requirements on pre-application for, and I went to the NASBA website, and our firm, even as a small regional firm, we go through NASBA. We are a registered CPE provider. We provide one course a year, although it's even already a speaker and the documents from Western CPE. We go through it so that there's no question. We also go through the hoop to allow it for CLE and pay the fee to allow attorneys to come into ours. And we have what I think is a very good annual, and that's a tax course, which may or may not help in this particular case. But it's not cumbersome. They've streamlined the process. It's not a fraternity to be a part of. It's a gatekeeper for us for quality CPE that we can count on, and that we're not having to try to independently judge whether this course or this speaking engagement is qualifies. So I would be not in favor of changing our.
Any other commentary? Okay, there is no motion, so we can end this conversation if the board so chooses. Okay.
Mr. Chairman, if I may, just to kind of put a bow on this, if the board's position is that at this time it does not wish to consider rule or policy changes relative to this matter, then a motion and a vote may be in order. Just
not change
to not do anything different than is currently in the rules and policies.
All right. At the request of Mr. Whitaker, do I have a motion?
Could I ask a question?
You may.
Mark, have we had any complaints from any other attorneys or groups that about how we go about enforcing CPE requirements?
Not to my knowledge, Henry. Not that I can recall, no.
Make a motion to go on record as stating that we have reviewed the possibility of changing and at this time do not want to make any changes to the current policies regarding CPE and the qualified sponsors.
I have a motion. Do I have a second?
Second.
I have a second. Any discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Any noes? Hearing none, the motion passes.
Proceed back to the original agenda. We have a review of several firm applications. I think the most efficient way to handle this is to they were all related to a certain issue. There's 4 new applications. Well, there's 3 new applications, one name change application, and then additionally there was the request from the Jeff Shepard CPA request that we've previously discussed. All 5 of these issues relate to 020-03.15, which states a fictitious CPA or PA firm name, that is one not consisting of the names or initials of one of the more present or former partners, members, or shareholders, may not be used as a CPA firm unless such name has been registered with and approved by the board and is not false or misleading. So we'll take these one at a time, I guess.
These come with no recommendation, is that correct?
Correct. The committee decided that because this involves, I'm trying to think, fictitious names, we felt it'd be more efficient to review it as a board in total.
But I think we also wanted to look at just the
ruling.
The ruling itself on fictitious names. It seems that we're kind of opening up more and more vague and absurd kind of sounding, and we're worried about establishing a pattern here with our fictitious names.
Right. That was our rationale, was to determine what this board's preference is going forward for these requests as well as future requests. So the first one we had was from Real Tax and Accounting. It was a request to license a firm with the name of Real Tax and Accounting. You want to take these one at a time, or you want to go through them?
Let's just name them out and let, I think this is a general conversation anyway, so.
The second was Call 3 CPA, which it's our understanding this represents Colossians 3 CPA. The third is Simple Accounting Solutions. The fourth is Enter Account PLLC. I'll note on that one that the applicant presented a few other options for names that if the Enter Account PLLC didn't work, they had submitted some additional names, which I'll read. Enter Account Accounting Services PLLC or Enter Account CPA Services PLLC. In addition to that, we've got also the review of the revised name change request for Jeff Shepard CPA PLLC. If you remember correctly, we had a conference call back in April, I believe, and let's see. We had denied the request for the application for this firm based on the ownership issues with that firm. Since then, the firm has come back and submitted a documentation showing that the ownership percentages have changed. So now we're back to the same rule here of a fictitious name application and whether or not we want to approve that. So I would say all 5 of these items would refer to the same issue at hand.
Mr. Chairman?
Yes.
I'd like to ask that we consider tabling all of these requests at this time, and that we as a board take a look at our rule here relating to use of fictitious names. It seems to me that that this situation could, if it's not already out of hand, it could get out of hand, that it offers an opportunity for non-CPAs to become owners of firms and not have their name presented to the public, not have their name out in front of the public. And it seems to me that that non-CPAs could hide behind these fictitious names and not be in a position where they would be perhaps regulated. I worry about these firms being regulated and being able to and how they're presenting themselves to the public.
And it notes in here that it should not be false or misleading. I think my fear is that we are basically allowing companies to insinuate that they have a specialty in some area when we can't really say whether they have that. And so we may be allowing the public to assume that we have authorized this.
Misleading.
Right. For example, the church audit and financial solutions, by okaying that, it's almost as if we're saying, yes, we know him, and he's excellent with audits of churches.
Mr. Whitaker, just from a legal standpoint, the Jeff Shepard matter has been a long-running issue at this point. If we table this, it goes to is it August or July meeting? July. What is your impression of there is some precedent for allowing these names. And I guess my question to legal counsel is, where does that put this board in this topic, especially as it relates to the Shepard issue?
I'd just like to be as clear as possible and make sure that I understand your question or questions so that I'm answering what is asked and not what I think was asked. Are you asking about the board's potential exposure from a legal standpoint for tabling any or all of these, especially
Correct.
Mr. Shepard? Okay. There could be some exposure. I will be upfront about that. How much, I can't say, and that would be for a Chancery Court judge to determine. If someone like Mr. Shepard and his counsel were to file suit in Chancery Court, it would be a declaratory action to try to have the Chancellor order the board to allow the name to be used. I don't have any specific information or knowledge from Mr. Shepard's counsel or from any of these other folks, counsel or no counsel, that somebody is going to plan to run to court the next day, first thing Monday morning, if the board doesn't grant any or all of these requests. But I also believe I would be remiss in my duty as board counsel if I did not at least advise the board of the possibility that could happen, and especially in Mr. Shepard's case, having been on the agenda for 2 meetings now, one of which called specifically to address his situation, there is some risk. And
my intention in asking this question is not to scare anybody here to make a decision one way or another. My only intent is that this is an issue that has been going on for some time, and we've gotten no resolution. And it seems to me that, I don't care one way or another, however this board chooses to vote on this action, but I think delaying it only makes us look like we can't make decisions. And so I'm strongly recommending that whatever we're attempting to do, that we attempt to discuss this issue and make some decision. And whether that has any blowback, that's not my intent. It's just we need to be decisive on these issues and come to some resolution on this matter. I feel like they're probably thinking they're just delaying because of some additional issues. And I just think we need to come to some resolution, especially on Shepherd, as to what we're doing. And if that's to approve it or not approve it, that's fine. I just think a decision needs to be made. And that's my commentary. That's no charge to anybody here.
I agree with that.
Mr. Whitaker, would it be appropriate for us to consider eliminating the provision or the rule relative to allowing fictitious names and grandfather in those that currently have fictitious names out there, and let them continue on and just discontinue the use of allowing fictitious names? Can we change that rule and just eliminate that part of the sentence there?
Before I would give what I would consider to be a binding definitive answer on that, I'd obviously like to consult with Mr. Crocker at some other time that is not today on the potential impact that might have on not only the board's position and reputation across the country, vis-a-vis national or other regional organizations of which this board may be a member or participate in, and also just to make sure that there are not other things that I haven't thought of that could be of some interest to the board as it considers such a decision. And if I might, I'd like to just kind of try and break down, I guess, the two main possibilities I see as to what the board could do here. Option A is for the board to say, hey, look, we see this as a problem now, and we find or vote that all of these name requests are deceptive and misleading. I would point out that if the board makes that decision, then I'd point the board's attention to Rule 0020-03-.15, and that's sub-item 3, and this is on page 53 of your books, and it reads as follows. The board may disapprove of the use of any fictitious name that falls within one of the prohibitions listed in paragraph 1 of this rule, or if it determines, after notice in a hearing, that the trade name is deceptive. And the two pieces of that are, if the board can look at items number 1A through H in that same rule, or item 2 in that same rule, then no notice in a hearing is required. The board could just make that finding, cite to the section that the name change request is violative of, and that's that. If, on the other hand, the board looks at the name change request and says, it doesn't fit cleanly into items 1A through H or item 2, then it would have to say, okay, we find that this trade name is deceptive, but then it says after notice in a hearing. I have to be candid with you that I don't know exactly what that means. I don't know if that envisions some sort of quasi or actual contested case proceeding before an ALJ, or if that simply means notice in a hearing from the standpoint of providing the requesting entity or person the opportunity to show up before the board, to be heard, and to provide whatever information they wish to in support of their request. I don't know which it is. Off the top of my head right now, probably say the board could and should at least start with the latter of those two options. For anybody they deny, to give them notice of that and to say, hey, look, this is the next board meeting. We are, your request is denied. We are giving you notice to come in here and talk to us about our decision if you want to provide anything you want to provide. I don't think.
I guess the issue I've got right now is that we have precedent in place on this issue, and we have a current rule that's in place. And I agree, if we feel like it's deceptive, then we need to just vote on that today. And I have no problems reconsidering the rule. But we can't affect that rule change for some period of time. And so I would suggest that we just consider these names as it stands under the current rules and make a decision as to whether or not we feel that they are deceptive or not. And how do we want to rule on that?
That actually segues into the other portion of my explanation, which would be almost exactly what you said, Mr. Chairman. Go with what you have today with your best evaluation, analysis, interpretation of these requests under the rules you have, but then also simultaneously be clear for the record that the board does consider this an issue that has, as Dr. Spiceland put it, somewhat gotten out of hand or getting out of hand, and the board wishes to and intends to address it as soon as it can, and will immediately undertake the process of doing that, which would probably look something like attempting to come up with amendatory language, whether it's just deletions of section under this rule, section or sections under this rule, or addition of new sections between now and the next board meeting.
I guess we could delegate that to the Rules Committee. Is that correct, to come back with some recommendation of what that should look like?
I believe
potentially.
I believe that's accurate. Yes, sir.
Okay.
Mr. Whitaker, can I get some clarification, please? Under 0020-03-.15, is 2 and 3, are they exclusive of each other, or are they to be read in conjunction with each other? And the reason I ask, before you answer, when I read 2, there's 3 things that have to happen in order for a CPA firm to get a fictitious name. One is that they have to apply to the board or be registered with and approved by the board, and it is not false or misleading. I read that as a conjunctive, and if 2 is not associated with 3, that means any one of the 3, if they fail, would not allow a fictitious name. Now, if I read that 3 somehow imposes with 2, then I would interpret it to say that we have to have a reason not to approve. Am I making sense?
I believe so, and if my attempted explanation betrays a lack of understanding of what you're trying to communicate, please say so. Just my initial reading is that on number 2, item number 2, that you are correct in that 3 things have to happen. I look at number 2 as primarily associating back with item number 1, and the reason I say that is because the very last piece of language in subsection 2 is say, and it is not false or misleading. Well, if you go back up to item number 1 defines what misleading is. So, you've got the 3 prongs, one of which has to be not false or misleading. Okay, well, what's misleading? Well, then you go back to number 1 to determine if it is misleading, and you go with it that way. If you get through that analysis and you find all three things in place that you would otherwise approve the firm, then I think your analysis requires you to move down to number 3 to say you may still disapprove of the use of any fictitious name if it falls within one of the things in item 1, or after notice in a hearing if the trade name is deceptive. Now, deceptive is not a defined term anywhere in the rules, but I think that number 3 appears to impose upon the board an additional analysis requirement beyond just that which is listed in number 2.
Okay, well, the essence of my question, and I appreciate that explanation, because that explanation leads me to believe that you say 2 is related to 1 and 3 is related to 2, which is related to 1, which makes it ambiguous, in my opinion, somewhat. But the gist of my question is, does this board have to have a reason to disapprove of a name that falls in one of these buckets?
If it appears, and this is just on-the-spot analysis, but it appears that if the board makes a finding that the name is misleading under items 1A through H, then no additional analysis or reason is required. If, on the other hand, it says, we believe the trade name is deceptive, then it would appear that the board would have to have some rationale, analysis, and explanation for that, especially if the Section 3 is to be complied with vis-a-vis the notice and hearing requirement, even if it's just for folks to come in and contest the board's decision or request that it be reconsidered after denial. I mean, the board is going to have to explain that to them somehow, and since deceptive is not a defined term in the rules, the board had to come up with its decision that the name change request was deceptive somehow.
What I just heard you say is we do have to have a reason to deny it.
If you say that it's deceptive but doesn't fall within one of the clear categories of 1A through H.
Yeah, so again, we have to have a reason. We can't just say at our discretion, we're not willing to approve it. That's what I'm trying to clarify.
I think that it would be difficult to defend if the board did so.
We can make a rule change to that effect, could we not?
The board may propose any rule change it wishes, and if it is approved by the powers that be, including the AG's office and the legal analysis review that this undergoes, then, and it does go through with no problems, then yes.
Thank you for the clarification. I just needed to know what the parameters were.
Sure.
Mark, in years past, my time on the board, I don't recall this becoming an issue as it is now. Firms, particularly regional or national firms, have changed their name. Has our board ever challenged it? For example, in the use of initials, it's really a fictitious name, BKD, BDO, KPMG. Yes, those initials at one time stood for a name, but have we ever disputed or when they've asked for a change of name?
Bill, we read this yesterday, I'm sorry, it does include names and or initials of current or former partners in the law or in the
Okay.
rules.
Passed away.
Okay, very good.
No, sir.
That really answers that question. I agree with the chairman's comment about dealing with the cases before us today and studying it going forward, and this is where I think we could, if we had knowledge as to how other states have dealt with this issue, could be informative or helpful as to how we do it. And, you know, this could be a place where NASBA actually could be helpful.
Okay, we'll do some research on that, Bill.
All right, well, I believe we've had enough of legalese today.
One other question.
Yes.
To be a registered CPA firm in Tennessee, do all the partners have to be CPAs?
In a registered CPA firm in the state of Tennessee, the ownership must be held primarily by CPAs, but you can have non-CPA owners.
Majority, basically, is that correct, Mark?
The majority must be held by
That was the
CPAs.
issue in the church. That, back to my prior life, no individual could be a partner in KPMG or Pete Marwick unless they were a CPA. If you were not a CPA, you had to, you first of all didn't have an equity interest, and secondly, you couldn't carry the title of partner, and it was either principal, senior manager, director, or some other sort, which all the firms seem to use. But our rule is that it just has to be a majority of them have to be CPAs.
Yes, sir. That is
Or the
correct.
equity ownership, okay.
Yeah.
Okay, so back to the original question. How do we feel about these names? Are they deceptive? Are they misleading? Where do we stand on approval or not approving the name changes?
I have one question about the real tax and accounting. Do we have a an approved name out there that's tax and accounting or tax and something or?
Let's see.
You mean another firm that's called Tax and Accounting?
Right, because one of the
They'd be the
things it
real-
says is it can't be similar, and I'm wondering why they put real in front of it anyway versus false or.
Unreal.
Unreal, yeah,
Unreal
it's
accounting.
really
Tax and
really
Accounting.
tax.
Extra, really.
Arlene, I can't answer that. I don't think we have anything called tax and accounting. I think we may have a tax and accounting solutions, but that is just
But
what's.
see, that's, again, tax and accounting solutions that's similar. So, again, we're back into a problem where, you know, are we going to be the A accounting firm and the double A accounting firm and the triple A accounting firm? I mean, this is.
Here's my commentary on all of this, is that if we're going to examine the rules, I think we've all agreed that some review of this policy needs to be made. I feel like we need to just look at these names. Now, that's a valid point. If that is similar to another name, that would be one reason to deny it. But right now, I feel like, I know we're all hoping that we could stop this at this point. The problem is that Pandora's box has been opened, and we are where we are today, and we need to determine whether or not these are misleading names. Or in that case, like you said, similar to another firm name or something of that nature. So
I would certainly think that Galatians 3 would be a misleading name.
I do too.
I just can't, well, I would think that'd be misleading. And I'm really beginning to think that church audit and financial solutions is a misleading name.
I agree.
That because it's religious-based, or what, is that,
Well, that's
well, church is
certainly
not,
part of it.
yeah.
I think that one of the things I'd like to see the committee, Law and Rules Committee look at is doing away with something, as I said, that insinuates that they are specialists in that area. I think that is, we know that law firms are not allowed to advertise a specialty, and I think that as a profession, we can't say whether that CPA really is a specialist in that, and I think by putting their name, by saying that in the title, it makes us think that they are. And I don't care what we've done in the past. I don't.
okay,
think
so let's take these one at a time. Colossians 3. How does the board? I've heard a couple commentaries. Does the full board agree with?
To clarify, it's call 3 CPA.
All 3 CPA. Okay. I mean, do we need to make this an emotion on each single one, do you think? Okay.
Yes, sir.
All right, let's do that then. We'll start with the 2 that y'all have already mentioned, just because there seems to have been some discussion on that.
I'd make a motion that they be denied based on being misleading.
Okay, so you're talking about Colossians 3, or Call 3 CPA, and church
Audit and financial solutions.
service. Okay. So I have a motion on the floor for 2 of the names to be denied. Do I have a second?
Second.
Okay, I have a second. Any further discussion?
Chairman, if I may just chime in, just one clarification for my notes, because if that decision goes through, then I'm going to have some detailed discussions with Mr. Shepard's
You are.
counsel. And I certainly don't mind doing that. It comes with the territory, but I'd like to be clear on what I tell him.
We do that and then get back to the rationale after the fact. I mean, we're saying it's misleading.
Right.
I think we have our rationale. As far as fleshing out your explanation to the attorney, perhaps we can have some further discussion about that after the fact.
That's
that-
fine, Mr. Chairman, however you would prefer to.
Okay.
To
I'm
go
just
about
trying
it.
to keep this moving along because
Sure.
we're getting bogged down here.
I move to amend the motion to include simple accounting solutions as well.
Are you,
That's fine, yes.
So we have an amended motion to deny Call 3 CPA, Simple Accounting Solutions, and Church Audit. Don't know the rest of the name, but Financial Solutions. So those three are there. I had a second. I'm not sure who was the second.
I second.
You seconded. Do you re-second? The amended?
Yes.
Okay. Any further discussion on those three name changes?
I'd just like to just go back and say that in the beginning, I suggested that we table all these.
Right.
We decided not to table them, and now we're going to either approve or disapprove each one of them.
That is
Okay.
correct.
That's fine.
Okay. So we have a motion. We have a second. Any further discussion? Hearing none, all those in favor of the motion, please signify by saying aye.
Aye.
Any opposed? Hearing none, the motion passes. The three name changes are not approved for Church, Call 3, and Simple Accounting Solutions. We now have remaining Real Tax and Accounting, Enter Accounts PLLC, and I guess they had some alternative names. Stephen, is that right?
Yeah, Inter-Account Accounting Services PLLC and Inter-Account CPA Services PLLC.
Okay.
I'd like to make a motion dealing with real tax and accounting that we investigate further to see what other organizations have a similar name and how similar. So if we could get a listing of anything that has tax and accounting in it currently.
Can I just make a comment on that? If we're denying Simple Accounting Solutions, should we really go down the road of investigating real tax any more than?
I should have included tax.
That's fine. We can pass them. I need to.
I'm
We'll just
fine.
take these separate. That's fine.
Okay. I would make a motion that we deny it based on.
Okay, so this is the real tax and accounting. I have a motion to deny. I have a proper second from Mr. Blofeld. Any further discussion on that particular one? Hearing none, all those in favor of the motion, please signify by saying aye.
Aye.
Okay. Any noes? Hearing none, the motion passes. All right, we have one left. Enter Account PLLC. I will accept any motion.
Does anyone know why it's what is the deal with Inter-Account? Is there any indication?
Data.
Well, it's spelled wrong.
I know it is, but I mean, it's like the impression. I don't know.
I mean,
I kind of get back to the same issue with the rest of these. If we're going to imply that none of these qualify, I don't know how you go down the road of suggesting that this, you don't even know what they do. I mean, that's the.
and they brought up the fact that that it might be misleading.
Right.
I mean,
Well, there's your answer.
So,
So I'll entertain a motion on this.
I think they made just a quick comment that it was, their argument was they feel that it was more ambiguous instead of deceptive.
I move that this name be denied as well.
Okay, I have a motion. I have a second. Any discussion? Hearing none, all those in favor of the motion signify by saying aye.
Aye.
Any noes? Hearing none, the motion passes. So all name changes have been denied, and I guess the Rules Committee probably needs to consider at the next board meeting some sort of potential rule change on the names aspect.
As part of that, could we get a list, and when Mark's getting his together, of anything that we've approved in the past that's, quote, fictitious, that we felt like wasn't, and look at the population so that we can get some saying, well, this really is fictitious under today's
Sure,
stop.
we can have that for you, Mr. Royston.
All right, Stephen, you got one additional item?
Last item I had was a request from Matthew Shillington for a waiver of credits in lieu of experience. Mr. Shillington graduated with a degree in accounting in December of 2011. He got a job in public accounting in January of 2012. At that time of his graduation, the rules, the CP hour rules were 24 semester hours in accounting. However, in June of 2012, there was a change from 24 hours required for accounting to 30 hours to sit for the exam. I think we weren't quite sure if, what the time period was, but to summarize, the time when he graduated from college, he was eligible to sit for the CPA exam because he did have the 24 hours. However, after working for I thought it was 2 years, that he did not have the requirements to sit for the exam because it had changed in June of 2012 from 24 hours to 30 hours. Mr. Shillington is asking for a waiver of the 6 additional college accounting credits in lieu of his experience that he's gained from working in the public accounting sector for the past 2 years, as well as the various CPE classes he's attended in the 2+ years since he's been out of college. We discussed this in great detail yesterday, and the committee recommends, or made a motion to recommend the board grant him 3 hours credit as an internship of the 3 hours requested. Additionally, the board, or the committee asked the board to consider to change rule section 0020-02.02, I believe it's section 1, item 1B, and make the change that allows, right now, currently our rules allow 3 hours be accepted as credit from an internship, and the committee recommends the board change that rule to make it 6 hours be approved for an internship for credit for the CPA exam.
But that doesn't relate to this individual.
It's two different things. The first one, regarding to the individual, we would recommend granting him 3 hours credit, which is allowed by our rules, of the 6 hours requested. That's the first motion that we would make as a committee. The second one, do you want to take that one now?
Let's go ahead and do that one if you want.
Yeah.
Okay. I guess I can take the motion from the committee. Do I have a second of that motion? Okay, I have a second by Mr. Haas. Any discussion on that particular item?
The reason that we could not, or even though we were so inclined to agree with the 6 hours, said our rule prohibits it. So that's where we were. And he, in his credit of courses, he had not received credit for a 3-hour internship in accounting at the time, so.
Okay. So I have a motion. I have a second. Do I have any further discussion? Hearing none, those in favor of the motion signify by saying aye.
Aye.
Any opposed? Hearing none, the motion passes. Okay.
The second motion, I guess we'll just go ahead and make a motion from the committee, is to change Rule 0020-02.02, Item 1B. Do I need to read that, or do you have it?
Just substituting the 3 for the 6.
That's correct. It currently says allows for no more than 3 semester hours or 4 quarter hours, maybe internship programs which may be applied to the 30 semester hours or 45 quarter hours in accounting. We're requesting to change the 3 semester hours, but let me go ahead and make that, and we'll have discussion. I don't know if I can make discussion in the midst of a motion, because we did not address the quarter hours, which I would assume it would be 8 hours. We would just double that. So, okay, so my motion is going to be that we change that item to 6 semester hours or 4 or 8 quarter hours.
Okay, I have a motion to change the rules on the hours granted for, or the credit hours given for internships. Do I have a second on that?
Second.
Okay, I have a second. Any further discussion? Okay, hearing none. All those in favor of the motion signify by saying aye.
Aye.
Any noes? Hearing none, the motion carries.
I'll make one last comment that we discussed yesterday in regards to Mr. Shillington. I believe that your application for the CPA exam is what it sets you into what rule you fall under, and I think it was our opinion that he could rescind his application.
He
Is
could
that-
rescind his application, but because we can't, the law isn't going to take so long to change, his best bet would actually be to continue with his application. As long as he meets the 3 hours accounting within 200 days, he can still go ahead and take the CPA exam. But that would be up to him.
It only takes how long to,
Otherwise, he's going to be longer waiting, but that would be his choice.
You know it's
voted
not
to-
going to be before the next board meeting because we're considering other rule changes, and therefore,
do them all together.
it won't even start that process for another quarter, so.
And it would be another,
And then it
probably
would be
6
another,
months.
yeah, 9 to 6 months, probably.
Mr. Eldridge, was your question how soon he could get that 3 hours?
No, I'm just saying he could always wait if he wanted to and not have to go back to school. He could always wait until the rule changes. But that I'm not recommending one way or the other. It's just an option.
Or he could do a summer session somewhere that offers such things, get it knocked out, and
Everybody understands.
That's right.
He's saying that
Okay.
if
he
he
didn't
did
wanna
not
pay.
want to go back to school,
I see.
He has the option to wait.
he has the option to wait until the rules changed and get his credit.
Thank you, Mr. Chairman.
Okay, thank you, Mr. Eldridge. All right. Mr. Royson's going to do probable cause in record time, I'm sure.
Ready to go.
Mr. Chairman, before we get into probable cause, I believe there was one other thing from Mr. Eldridge's committee yesterday. I hope it was. I may have lost track of committees after today, but we have to do a regulatory flexibility analysis of the rules that are already working their way through the process. And that's just something that, as the board has experienced before, that I just have to read it into the record and then a vote to approve. Not sure, was it Mr. Eldridge or Mr. Brewer? Oh, okay.
Yeah.
Was that the thing we were trying to get you to read in yesterday? That
Well, I gave the committee the option to
I'm
hear.
kidding with you again.
Y'all didn't want to hear it yesterday.
I was trying to trick him into reading it to us. He said he
It's not
couldn't.
Chris's day.
Yeah.
Oh, my day
Sorry,
is
we
just
needed a
fine.
laugh.
You know,
We needed a
I
laugh.
just don't
It's been
wanna
too
bore-
serious.
I just don't want to bore you to death. that's
We're
all.
sour on attorneys today.
Okay. This will be the regulatory flexibility analysis for the rules that are currently working their way through the rulemaking process. The amendments are to Rule 0020-01-.08 regarding licensing and registration requirements, Rule 0020-04-.03 for grounds for discipline against licensees, and Rule 0020-5-.03 relative to continuing education. The Regulatory Flexibility Act at Tennessee Code Annotated, Sections 4-5-401 and subsequent sections, requires that prior to initiating the rulemaking process pursuant to TCA 45202A3 and 45203A, all agencies shall review all proposed rules and the effect that the proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The Act further provides that the agency shall consider without limitation certain methods of reducing the impact of the proposed rule on small businesses while remaining consistent with the health, safety, and well-being of the public, and those methods are as follows. The extent to which the rule or rules may overlap, duplicate, or conflict with other federal, state, and local government rules. The clarity, conciseness, and lack of ambiguity in the rule or rules.
the establishment of flexible compliance and/or reporting requirements for small businesses, the establishment of friendly schedules or deadlines for compliance and/or reporting requirements for small businesses, the consolidation of simplification of compliance or reporting requirements for small businesses, the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule, and the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, and/or increase costs. The description of the proposed rules are as follows. The Accountancy Board intends to convene a rulemaking hearing at a date to be determined in order to adopt amendments to the rules governing the Tennessee State Board of Accountancy relative to payment of professional privilege tax, continuing education, and the adoption of a military applicant rule, which was necessitated by a legislative amendment in 2013 in order to provide an expedited licensure process for certain military personnel and their spouses. The proposed amendment to Rule 0020-01-.08 would add the military applicant rule, the text of which the board has seen at a prior meeting, to that language to the board's rules. The proposed amendment to Rule 0020-4-.03 would provide specific, unambiguous authority for the board to impose discipline against a CPA for failure to timely pay professional privilege tax as required by law. The proposed amendment to Rule 0020-05-.08 would remove ambiguity from the current rules by clarifying the exact circumstances under which the board could seek to assess penalty CPE hours against a licensee. The regulatory flexibility analysis as to the methods of reducing impact of rules on small businesses is as follows. Number one, whether the rules overlap, duplicate, or conflict with other federal, state, and local government rules. Analysis has determined that there is no overlap, duplication, or conflict with other federal, state, or local rules. The clarity, conciseness, and lack of ambiguity in the proposed rules. The rules are clear in purpose and intended execution. The implementation of the proposed rule changes will increase clarity and conciseness and will decrease ambiguity in the rules as a whole. Number three, flexible compliance and/or reporting requirements for small businesses. These rules do not create any new compliance or reporting requirements for small businesses. Number four, friendly schedules or deadlines for compliance and/or reporting requirements. The proposed military applicant rule will expedite the licensure process for certain qualified military personnel and/or their spouses. Otherwise, these rules do not set out any further or additional compliance and reporting requirements. Item number five, there are no new consolidation or simplification of compliance or reporting requirements. There are no new compliance and reporting requirements other than those previously referenced relative to the military applicant rule as a result of these proposed changes. Number six, performance standards for small businesses. These rules do not set out operational or design standards. As such, there are no performance standards for small businesses to meet as a result of these proposed changes. And finally, item number seven, barriers or other effects that stifle entrepreneurial activity, curb innovation, and/or increase costs. It does not appear that these proposed rule changes will erect barriers or will have other effects which would stifle entrepreneurial activity, curb innovation, and/or increase costs. This concludes the regulatory flexibility analysis, and I will turn this back over to the chairman for any discussion deemed necessary. And at the conclusion of any discussion or deliberation, we'll need a motion and a vote to approve this analysis.
All right. Mr. Royston.
Thank you. We have before us $13 items.
Royce, if
believe-
I can interrupt for just a minute, we do need a motion and a vote on the regulatory flexibility analysis, Mr.
I
Chairman.
move approval.
Have
Second it.
a motion, have a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, the motion carries.
You were inspired by the log judge, huh?
Yes, Mr. Royce and I aspire to be an administrative law judge, just like Judge Summers.
I believe that you still have on your iPads 14 items on Chris Whitaker's report. Are you passing that corrected? Okay. We're about to have 13 items. Just a moment, please, to read over those. They are the same ones that were sent to you, with the exception that number 10 in the previously issued draft has now been deleted.
Does that mean it needs to be deleted, or it's coming?
No, it's gone in what you are, the paper version. What you're working on, if you had questions based on number 10 that's on the iPad and what you were emailed earlier, it's now, it was removed from the list. So it's the difference in the two lists. We're acting on the paper version you have in front of you. Mr. Whitaker, do you have any particular instruction on any of these items?
Thank you, Mr. Royston. Relative to the item that was removed, believe the probable cause committee's rationale for that was to simply defer this matter appearing on the legal report until probably the July meeting, pending receipt of additional documentation relative to what appears to be an imminent settlement of the civil litigation related to that matter. And that is perfectly acceptable, and as such, based on the committee's vote, that item was deleted, and therefore giving you the draft with the 13 items in front of you. Now with the 13 items before you, okay, going by the new numbers here. So items number 7 and 8 are related. The two complaints are against a CPA and the firm for which the CPA was employed at the time of the complaints. This was also the matter that some board members may recall having been referenced, the board having to retain an expert witness in order to render an opinion on a couple of pending cases to determine if sufficient proof and probable cause existed to move this matter forward through the formal hearing or settlement process. And the summary before you outlines what the expert came up with and staff and management's recommendation as a result of that. Item number 6 above that was also previously in litigation monitoring status. The CPA in question was alleged to have misappropriated quite a bit of money from an elderly former client. Unfortunately, that client passed away prior to the ability of the board and staff and other agencies investigating this matter to move any of the related matters forward to a conclusion. The civil lawsuit that was filed against this respondent was dismissed at the insistence of the now deceased complainant's children, who are the executors of the complainant's estate, and without their participation and assistance, there was no way for the civil litigation to be proved up, and also some of the same proof problems that were there would have been present in the criminal allegations against the respondent, in that without the respondent there to personally testify to certain things and authenticate documents and the like, neither the litigating attorney in the civil case nor the district attorney's office, who had initiated criminal charges against the respondent, felt that the charges could be proven up. And as I understand it, our own securities division took a look at this matter briefly and came to the same conclusion, and we've been notified that they will be taking no further action. Beyond those three things, the investigation on the board's end was unable to come up with substantial independent evidence to conclusively prove or even get us to a probable cause determination that we could prove any of this at a formal hearing. That's why the recommendation is for dismissal in that matter. And I believe those are all of the special, unique ones. There was some discussion on item number 1 after reading the summary, but if that discussion was concluded in committee, and if after reviewing that item the full board wishes to discuss it further, I'm happy to address it as needed.
Okay, has everybody had a chance to review the documents? Item 1, because it is actually a suspension, I'd like to handle items 1 and 2 separately. And we can
Mr. Royston,
combine
the
some.
recommendation is for 5 years probation, not
Okay.
suspension.
Mr.
I thought it was for, just okay, suspending, you're right, sorry.
That was the self-report. There's another one in here, I think.
I would like to just say on item number 1 that I think the proposed settlement on that is it's inconsistent with what we have done in the past. I think we need to take a real hard look at what was actually took place here, and consider a different type of penalty on this particular individual, because basically he embezzled over $10,000, and all we're doing is I'm not sure we're even slapping him on the wrist, but I think that a much more serious type of penalty needs to be assessed in this case, especially in light of the fact earlier case where we assessed a $5,000 penalty.
Now, he did self-report, he did turn himself in, didn't he?
Yes.
He wasn't caught, he admitted that he had done wrong, made
Or
rest.
maybe he got caught and self-reported to us.
Before somebody could report
Right,
to us.
right.
That's probably the reality.
Did we investigate this?
Mr. Butler, I believe, was the investigator on this matter. I'm sure he can speak more detailed to the investigation beyond my summary here.
Mr. Butler, can you fill us in on some details, please, without revealing names and all, so that we're offering him 2 options, a formal hearing with whatever we put on it, or a settlement on it, so.
Ray, microphone.
He was told that if he didn't report himself, they were going to report him.
Can I make a suggestion on number 1, since we're having some issues here, that this be, do we need to do formal hearing on something like this? Or are we talking about suspension of license? Do you want to do consent? Or do you want to have the facts or information behind it?
Well,
Is this
I think
such a
that's what
case?
we're trying to
Yeah.
do, that if we want to offer him something, when this was presented to us, that was not part of it. It was self-reported, period, and maybe we didn't ask the question. In future, if we've got something that's part of the record, we need to know that when it comes to us as a board, if that's appropriate, so that we're not sitting here looking like, well, he did self-report. Well, he self-reported because our investigator knows. I want to know that when it comes out on this report in the future.
I agree with Mr. Haas. This is about the worst thing a CPA can do.
Right,
is theft.
exactly.
And at the end of the day, the point to this board, I guess, is that maybe I'm biased, I don't know, but these people tend to repeat history, and I would certainly hate to have something of this serious of a nature come back a second time if we didn't sufficiently handle it the first time.
Right.
So
All right, would you fill us in on a few other, if we need, that in itself
Okay.
changes my thought pattern on it.
I don't have his file in front of me, but I believe it was something less than 10,000, but it was darn close to what he stole. appropriated, was his words. And the way they handled it is they had another CPA look at it to arrive at what the loss was. That CPA who informed the fellow that if you don't turn yourself in, I got to do it.
And Mr. Royston, I'd like to point out, when I wrote this summary, I was going off the respondent's self-reporting letter, which was pretty detailed, and, you know, in the interest of candor, he made no mention of that at all.
Okay, can we work with our investigators? And I'm not sure where the line has to be drawn between investigators and our staff attorney in presenting stuff to us. But if there's things that our investigators feel important, or important facts, such as he may have self-reported, but he was told he was going to get turned in if he didn't, then those need to be put in our reports within the guidelines. And maybe we have to be harder at the committee level, and I'll accept that responsibility for not asking that particular question.
Okay, well, let me ask you this. On number one, would somebody like to make an amended consent offering? And it's up to this individual whether or not they want to contest that penalty if we feel that this is the extreme that we need to take on this one. So I don't know about monetary, but
Mr. Chairman, I'd like to amend this by asking that his license be suspended for 5 years.
Do I have a second?
Second.
I have a second. And then we'll look at the other part of it. At that point, now, are you supposed to take the votes or am I?
You can do it.
Okay. I'm just,
you're not stepping on my toes.
okay. Just don't want to. We have a proper second and a motion and a second for offering in the consent order, instead of payment of a civil penalty of X amount, the license will be suspended for 5 years instead of on probation.
Are you keeping the monetary in place? Yeah.
I do have one question. Did they decide not to press charges with the company?
$9,000 in restitution, I guarantee you they didn't, just as a practical nature, they didn't do it.
All right. Did you amend your motion then to include the 5,000, or was that part of the original
No, that
motion?
was already in here. I just,
All right, so
I
you're
just
saying
added
just to change that. And was that your motion then, Charlene, to, are you
I
understanding
was
that?
second his, yes.
And that was to leave the
was just
5,000.
5,000.
Leave the 5,000 revoked license.
All right, I have a motion on the floor and a proper second. All in favor, say aye.
Aye.
Aye. Opposed, like sign. Okay. Item number 2, this is a CPE requirement case. The recommendation, consent order for a penalty of $1,000 and a whole lot of CPE. Is this up to date, current for the current renewal year as well? Does this include what it would be required?
I believe
And
this
that doesn't
would,
count towards our current 13-14. This is,
no, this is for the 11-12. This would take this respondent up through the period for which I believe it's a she was audited, and also impose the additional penalty hours to get them up through for that particular reporting period. If the board also wishes to add that this respondent undergo a mandatory CPE audit for the 13-14 reporting period, that may be something you wish to consider as well. The board has done so in the past on a case-by-case basis, and I figured I would bring that up as a possibility if that is something the board's interested in.
that's something we do. Isn't that something we normally do anyway, or and is it something we need to do, Mark?
We normally do it anyway, Don. You can certainly make it part of the consent order if you wish, but it's something we normally pick up on.
Well, if anything, you put them on notice that is what's going to happen.
I think it's a good point, Christopher. I would entertain a motion then at this point to amend that, assuming Everybody's in agreement with the recommendation.
I'll make that motion.
Have a motion and a second.
I'll second.
All in favor, or is there any discussion? All in favor signify by saying aye.
Aye.
Opposed, like sign. Okay, 3 and 4 are privilege tax cases. And, let's see, 5, I believe is that, no. 3 and 4 are privilege tax cases.
Move to-
Move
move
have
to
a
accept
motion,
the-
proper motion. And do I have a second?
Second.
Discussion? Hearing none, all in favor say aye.
Aye.
Opposed, like sign. 3 and 4 approved. Got 5. Does anybody have any problems with 5? And I'm just going to, these others are not as much of a hot button, and we'll handle them together in one motion. Does anybody have any questions on 5? 6 and I'm going to skip 7 and 8 combined for just a second. 6 and 9 are removal from litigation monitoring with dismissal of the complaint. Have any problems with either one of those? 11, I'm skipping 10, 11 and I think it's it, isn't it? 11 and 12 are, and 13 are dismissal. No, wait, no, 11 and 13 are dismissal,
Yeah.
excuse me. Anybody got any problems with either one of those? Or have I confused the issue?
Make a motion for all 4, is that what you're saying? Or- I make a motion that,
At the list. All right, that would be 6, 9, 11,
11 and 13.
and 13. Do I have a second to that?
Second.
Any discussion? All for approval, signify by saying aye.
Aye.
Like sign. Motion carries. 7 and 8 were combined. This is litigation monitoring as well. It's a little, because it's been on the plate a little longer, I wanted to give it an opportunity, if there's anything else we need to know about this particular one, that or investigators jump in if anybody has any questions on it, whether it ought to be dismissed or not.
Well, at the end of the day, I believe that the board has done all that it can do relative to this matter. It was and is a very complex case. The short version is that the complainant was dissatisfied with the expert witness testimony and report work done by the respondent CPA and his firm. And, throughout the course of the trial, there were some issues on the part of the complainant about what they thought could be excessive billing, and also they were unhappy that the trial judge elected to disregard the findings of the expert witness report. However, the expert witness that was retained by the board reviewed literally thousands of pages of documents, including trial transcripts and pretty much the entire known universe of documents that we had and gained access to. And as to the expert report, our expert found that the methodologies and analysis and work product done were acceptable and within the norms, but that it was his opinion that the trial judge disregarded the conclusions because of informational gaps caused by the deliberate and intentional withholding of evidence from the defendants in the matter. And so therefore, the judge did not come out, in our expert's opinion, did not come out and say, Mr. CPA, you padded the bills and didn't do good work, and that's why it's getting tossed. Instead, he said, I like your formatting, your testimony is fine, and this has some other utilities, but I can't accept your final numbers because there are gaps in the information that was provided through the discovery process, and therefore I can't take the numbers. And then as to any violations of the law and rules based on the entire course of conduct for the respondent CPA and his firm, our expert stated flatly and point blank to me that he could not testify even beyond a probable cause standard to one violation of the law or rules if called to do so at a formal hearing. And the board has spent a fair amount of money to retain this expert, and it appears that he's done what he's supposed to do given the report that was requested. And that's, I think the board has gone above and beyond to look into a very complex matter and has some findings on which it can hang its hat for this recommendation.
Thank you. That's a very important summary for the board to have in the permanent record, as well as why we acted we did. Thank you. Any more discussion on that particular one on 7 and 8? Entertain a motion to approve.
So moved.
Have a proper motion and a second. All in favor say aye.
Aye.
Opposed, like sign. I believe that leaves us with number 10 and number 12. Number 10 is purely CPE. Entertain a motion to approve that one.
So moved.
Have a second?
Second.
Any discussion? All in favor say aye.
Aye.
Opposed, like sign. Motion carries. Number 12, this is a letter of warning. And having read some of the letters of warning in the past, I think they explain the rules very well and explain the consequences if you don't follow them. And I assume we have this in monitoring status coming forward. Do I have any questions about number 12? Any discussion on it?
Mr.
Or motion?
Rushton?
Yes, sir.
To your point, didn't want to leave out anything that the board might wish to consider, but typically, when it comes to the use of the term accounting or things like that that are resolved by C&D letter or letter of warning, typically once those cases are resolved, Mr. Mills typically covers most of East Tennessee over to Nashville, and then Mr. Butler from Nashville West. If there is follow-up required, for example, if there is signage that needs to be changed or a website that needs to be changed, those things will be looked at, investigated, and confirmed that the changes that were required to be made were in fact made. And if they were not, then those entities and/or persons involved in that would be the subject of a new complaint, especially having been warned in writing by the board about the fact that this is the case, it needs to be changed, and if you don't, it could be more serious down the road.
Thank you. Do I have a motion to accept the recommendations?
So moved.
Second?
Second.
Have a second. Proper motion and second. Any discussion? All in favor signify by saying aye.
Aye.
Like sign, no. Motion carries. Don Mills, I believe we have a report, quick update for you on the case status that's in the, that's on the iPad.
On your iPad. I've included it, as well as the status of open complaints, which I always do, which you can see on my first page there. We're down to 40 cases, 14 that we heard, and that I'll have to amend that to 13. You can see how those break out. The thing I added this year on the third page, I did a summary of board action for the entire calendar year last year. It's broken out into two sections, the complaint status and the board action. If you walk through that with me, complaints open in 2013, 94. Board action on those complaints, 56. Then in January, we heard 24 more that were in the prior year. We had 7 closed without board action. That would be cease and desist orders. giving us a balance of 2013 complaints that were not heard of 7 for the year. All right. The second part is basically tallying up what action the board took on complaints opened prior to 2013, 45, the complaints of 2013, 56, and then, of course, again, our 24 cases that we heard in January. So the board heard a total of 125 cases related to that time period. Average days to the hearing, that's between the receipt of the complaint to the time the board takes the first action. Average is 113 days, and there's your range from 46 to 198 days. I'll be glad to, if y'all like this format, I'll be glad to update it with each passing. All I have, Mr. Chairman.
Thank you. Anybody got any questions?
Mr. Chairman, I did have one addition. In the division complaint, quarterly complaint meeting that Mr. Crocker and I are required to attend, we received excellent feedback from the powers that be about our case management process, moving it through the pipeline, keeping things moving. They're very pleased with our performance measure, which is somewhere around 88%, which is up from 11% when I started. And then I also received excellent feedback from my direct supervisor about the performance measure issue as well. So I thought the board would like to hear about that.
Thank you. And we could tell, Don and I had talked about this, I guess, at the October meeting, about trying to get some movement on how old cases were and how we were doing on the current cases. And I thank you for your new format, and I think it's very beneficial. That concludes my report, Mr. Chairman.
Thank you, Mr. Royston. Old business, Mark, we have the questions surrounding the CPE tracking tool and the NASBA tracking tool, and our issue of, is it required, not required? I think we have said that it's not required to maintain your CPE, but if you come under audit, there may have been the implication that it was required. And quite frankly, I can't remember at this point what we did say. But all that to say is that it is ambiguous and people are confused. And so we need to clarify the board's stance on the CPE tracking tool as it relates to the auditing of CPE credit.
Mr. Chairman?
Yes.
When I voted on it, I thought, my understanding was that it was a totally volunteer program for monitoring as well as during the audit period. And if that is not the case, I move that it be optional during the tracking period as well during the exam period, or don't have to convert it all to the NASBA format in order to be subject to audit.
Okay. Does anybody have any strong objection to it being voluntary? I'm just curious from a board perspective.
But I would second that motion.
Okay.
I don't know if I have an objection or not, but I'm curious to know why our firm, a lot of the firms out there that have CPE tracking systems can't download that information to NASBA.
Well, I think NASBA had addressed that. We had this link. I remember Mr. Eldridge actually asking a lot of those questions.
Yeah.
That it's not fully capable of doing so at this point, right? Without some customized.
There was too many of them out there
for them to
fix it, to fit in with every one of them.
So that's what we've run into, I guess. Then some of these firms can't download.
Right, and if then all of a sudden you're in a position where you're like, well, you got to keep up with it two ways, or you're required to use the NASBA product for everything, right? I mean, and I don't know, was it actually a firm-wide solution? I can't even remember if it was just an individualized thing or.
I think it was just individualized. I think some of the other proprietary
I'm not sure
programs-
you could track your entire firm with the product. Now, I may be misspeaking on that, but my point is that we would be, in effect, telling people, you have to use this. So you're either going to key it in twice or use this as your tool to track the CPE.
I mean, in a way, that's kind of ridiculous to have people key it in twice.
That's right.
I didn't understand it that way. I thought that the firms would be allowed to download their information to the NASBA system.
I think
And
there's
that's
some
what
technical limitations to that.
That's what I have talked to some firms about that have mentioned it.
Is it correct that the TSCPA, though, can put all their information through?
Wendy, you may be able to answer that. Are you saying using their tracking tool?
Right, so
Yeah.
since the majority.
I don't know. They have their own product, so.
We have our own product for members in which they can track any CPE they take through us, and then they can manually input CPE that they take from other providers. We provide, obviously, confirmation on something that's taken from us.
Well,
I think what she's asking is, can the Tennessee Society's system download into the NASBA product? Or have y'all even attempted
I
that?
think that that's something that could have been, could be discussed at a future time. It's not something we were interested in jumping in on at the beginning.
I thought that was what we had the whole discussion on, that they were going to make that happen.
Well, and I think that's why the conversation shifted, and I think that's why Mr. Blofus remembered, and that's kind of my recollection, was that there was technical limitations, and it was going to be a very big burden on the population to comply with that particular product, and therefore it wasn't required, it was optional. And again, that's my recollection. But either way, I think there are technical limitations as to doing that, and I'm not sure we can force our people into a system like that without creating substantial problems.
Not today.
Not today.
Wendy, out of curiosity, can you accept scanned documents into your system?
Yeah. Yes.
Okay.
Mm-hmm.
If I could just add, as the person who reviews the CPE audits, I think there's a misunderstanding about how difficult it is to add courses to the CPE tracker. If a licensee, and this will affect, roughly the 500 people who are audited each year, if a licensee has all of their credits through the Tennessee Society and they have the tracking sheet that the society provides, that will be one entry into the CPE tracking tool. They would simply say, I have TSCPA programs from this date to this date. They would upload the one document and then allocate, there were 8 auditing classes, there were 8 tax classes. That's as simple as that gets. The same for if they have a tracking tool from their firm.
You're not going to take on the tracking tool from the firm, you get one sheet that says they've got it. Are you going to accept that one sheet, or do you want to see the supporting documents that you always ask for?
Yes, just like if they were to submit it just as a paper audit like they did last year, I would accept that tracking sheet from their firm as proof of their completion of the CPE.
Have you had a chance to tell people that it's mandatory for their audit? I mean, this was all, when was it passed? When did we?
In October.
So it would have been in effect at the end of last year. Did you communicate to people that it was required for, I don't know if that was you or?
When someone, I have sent out a letter to all of the active licensees. When someone becomes licensed, they get a letter with the link to the site and their password, instructing them that the tool is available to them throughout the year if they choose, but
really what I'm asking is, in the audits that we conducted at the end, for the end of last year,
No, those were.
has anybody used the tracking tool for an audit yet?
No, not yet. We haven't.
Okay.
We haven't had an audit with this tool yet.
So it appears that most of this is just maybe a misunderstanding. Everyone's reacting to something that.
Well, no, I'm not sure it's necessarily a misunderstanding. I think people are worried about the fact that they got to use 2 systems if they're selected by audit, or for audit for CPE credit, because they are going to have to put, maybe it's not as cumbersome as people think it is.
I mean, you've got to get that
But again, it's
piece of
another
paper.
step.
It is, but you have to get that and send it in anyway, don't you?
Well, I mean, if your system prints it out and you've got all the documents there, you just forward that in an email to her and you're
Right.
done.
Our system, you hit
print
a
it.
button and it prints the report and you send it in. It takes 5 minutes to do it. This way, you've got to go in and key it in. My recollection is we were encouraging use of this to make it more streamlined for the audit process. However, we did say there were options if people requested not to use this. If am I remembering that correctly? We didn't say you absolutely had to use this for audit. We just encouraged it.
Let's back up a minute. At the end of the meeting, there was a question about what Missouri had done. And in Missouri, they simply required use of the CPE tracking tool unless you did not have access to a computer. That was the only carve-out that Missouri had. Since then, Virginia has adopted the CPE tracking system. They are not allowing any carve-outs at all. You must use the CPE tracking.
The NASBA CPE.
That's not
Yes.
that's not our understanding.
That is our understanding.
In Virginia?
Yeah.
Well, let's just decide today what we think is good for our group. I mean,
Motion on the floor.
yeah, we have a motion, and I guess you seconded that, did you not?
Yes, sir.
Is there any further discussion? Do we need to refresh everybody about the motion?
Yeah.
No, my motion is that
It's
the
not
use of the
mandatory.
NASBA CPE tracking tool is encouraged but optional, even through the audit process.
That was my understanding on my second.
Discussion.
I would ask that you consider that when NASBA is able to download a firm's information, then at that point, that firm would be required to do that.
That we could.
I'd like to
Problem
see.
with that is, and here's my only objection to that part, is that different people come on at different time potentially, and some are required to do it, some are not because of where their system is in the process. I mean, to me, the whole useful part of the NASBA tracking tool was to direct audit, not necessarily to track audit. Do you follow what I'm saying? In other words, if the whole population was being required to use the system, then when they selected the audit, they could go in and see what people had. I mean, it would self-audit itself, and then you would select those few people that did not have the stuff keyed into the system properly. And that's who you would be auditing. It was more of a targeting tool. I mean, I may be speaking off topic here, but it was my understanding it was more of a targeting thing than it was a management of, I mean, it does the management piece, but I think the benefit to us was that it directed our audit process.
I think we need to put the onus on the TSCPA. It seems to me that's the largest holder of data in terms of the CPE. They should get together with NASBA and get this working.
I disagree completely. You've got NASBA offering something. We've been using TSCPAs forever. NASBA now has a new tool that we've said, hey, this is a good tool as well. And we encourage people to use it, and we'll use it. We've already told TSCPA that we will, and this is the first time I've heard that if you send in the TSCPA certificate, that you don't have to have any, and you have added your own stuff to the TSCPA tracker. I mean, what if these that gave us, our gentleman this morning, had just put those lines down into the CPA tracker? Would we have accepted his CPE?
In the TSCPA tracker?
Yeah, he's got the right to do that. That's
So
not
you're
what I
saying
see as
there's
an
no
audit.
audit behind the TSCPA tracker?
There's not, is there?
Our transcript, which is the official, what I understand the board staff uses as official, the transcript only includes courses that we offer and can verify. We also allow non-members to add. However, we don't include those courses in the transcript because we can't verify those. Those would still have to be verified.
So what are you accepting now?
But it's a place to house everything, just like the NASBA tool would be. So people have been doing this for years.
You also allow us to enter courses that are not offered through the TSCPA. We can, if it's a AICPA course that we've taken, we can come back and load it into your system and have it there to complete all of our CPE information.
But she's indicating that they do not verify anything that's there, and when you get the transcript, it does not have any verification of that, so it doesn't show up on
It's
the
just a repository of certificates.
Right. You can pull what we call a tracker that would include everything, but of course, we can't verify what you did not take.
They're not going to
through
certify
us.
something they didn't offer.
Right.
But
right.
but if I understood a minute ago, we can send documentation supporting that particular class to the TSCPA. Can we load that,
We have
download that?
we're either, it's just been released to be able to upload those, or it will be very, very soon to upload certificates, yes, from other vendors. So yes.
But what do you accept?
Well, I'm familiar with the society's tracker, and it's very clear on it which courses have been approved and are verified by the society. And then following that will be the following courses you've entered, but we cannot verify. And for that, in that case, I would ask for certificates for those courses.
So, there are some firms out there, and particularly LBMC, that goes to an awful lot of trouble to track all of the CPE that's provided to their CPAs. And they've got a fairly large tracking system. I think the Cosmo has a pretty good tracking system. And there are a number of the firms.
National firms.
Yeah. Have got.
I just have a fundamental problem, I think, mandating that our group use a certain product.
Well, I'm not saying they need to change anything at all. Those of us that use
or even added on to that, have to key into a different system for which they've already been tracked.
And I don't disagree with you. I don't think that we should require them to change, nor should we require them to key into a second system.
Right.
But what I'm saying is that at the end of the year, and at the end in January, that TFCPA be able to download their data into the NASBA system, and thereby having and then all the firms be able to download it in late January into the NASBA system, and there you've got everything consolidated into one database that they can audit.
NASBA's the one that's got to make that
happen. They've got to make that happen. If they don't make that happen, well, then we can't require it.
I agree.
Why does it all need to go in the NASBA system? Why can't, I just heard that she's got access to the TSCPA system. So is that correct?
No.
No.
Oh, I'm sorry.
No, and I think the NASBA thing not only would allow for the access for them, but also state to state. As soon as other states incorporate this, that's what they're trying to do. So it's like a communication that would be very easy. And for them, they'd have immediate access.
And I don't care what vendor we use. We need to have something to be in the 21st century for electronic reporting. And whether it's our own system that will accept all different vendors, including NASBA and TSCPA or whoever, but we need some sort of platform. I don't care who it is, but it needs to be something that we can streamline and automate our process with. But I agree with the issue of requiring our members to use one specific vendor. I don't think that's correct. But
I think we have to push, again, the TSCPA and NASBA. I don't care who does what, but until we get at least one large vendor like the TSCPA and NASBA to work together, we're not going to get the other firms and their small vendors to do this. So we have to get a push somehow. We could require our individual members to use it, but I agree that's kind of forcing something on them that they're going to be very unhappy with. Right. But unless we do something, we're going to be in the same situation in 5 years. While other states are moving forward, we need to encourage a upgrade of some kind so that this is what's going to happen in the future.
Well, also, I'm not sure how many of you are familiar with the Future of Learning task force that the AICPA is working on. And just to try to be very brief, it came out of the 2025 Horizons. And the whole landscape of continuing education is going to be changing drastically. So to mandate something now for what we have in place now might be something that has to change again in 5 years anyway, because the way that they are looking at potentially delivering, measuring CPE is drastically different. From getting rid of the 50-minute hour to nano learning to all sorts of different ththings.
I don't think that's going to change the fact that we're still going to require CPE. It may be that we require it in a different way, but the issue I have is that all the platforms we have do not communicate with our state auditing process. NASBA has presented something that does. So my request is, why don't we have other, starting with our state society, making this communication possible?
At this point, it's time consuming for us. I think I brought these up at the concerns at the last meeting. There's a cost issue. It's just not something we're ready to jump into when we already have our own system.
But your system
And
doesn't-
in addition, we've got firms and many firms and individuals who have complained about having to do another system when they already have something on their own.
We're not, that's the whole point. We don't want them to have to do another system if they're using the TSCPA. If we got one large group to do this, the other smaller ones, knowing that there's already a means to communicate, because somewhere along the line you have to come up with the language, the fix that puts the two together, and that probably could be easily transferred to these other vendors.
Well, the question is, who's going to make that investment, is what Wendy's saying, in time, resources, and money.
Time, resources, money, there's data there's data concerns from any vendor from a firm or any kind of CPE vendor is going to be worried from a data perspective as well. So I think that if it was something that was voluntary now and we could see how it worked and we could see how other states adopt it, then potentially the TSCPA would be more interested in jumping in when they would know what they were getting into.
The only issue I have, I guess, is if we do this, and obviously I think automating this is the right way to go, but if our staff is getting this in 20 different ways, does it become confusing to figure out, all the different reporting styles and that sort of thing? I mean, at least
But
require.
they have been getting it 20 different ways. I mean, they've
We
been.
get it in paper form and.
Right.
What's your thoughts? I mean,
Well, an audit, the audit process is time consuming no matter how you look at it. I have a really intricate spreadsheet, and last year was the first audit that I did myself, and it was basically keeping track of 500 emails and the documents that came along with them, and just hoping that no one was falling through the cracks.
are you okay with that if we just had a voluntary position and you got it?
Oh, sure,
all different?
I can do it either way, and if it comes down to that on my, when I'm tracking this on my spreadsheet, I could note if someone has already responded via the tracking tool.
We have a motion. We have a second. Any more discussion?
Are we, I have to keep asking about this. Are we basically now?
We're not making it mandatory.
Okay,
for
we're
either.
just confirming that it's voluntary.
That is voluntary.
Okay.
Encouraged but optional. was the
Encouraged but
wording.
optional.
Yeah.
Okay. All right, hearing no further discussion, all those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, the clarification is passed. Okay, Wendy, you were up next on the ERISA audits and peer review.
Try to make this concise. Everybody's hungry, I'm sure. I think you saw in Mark's executive director's report that he heard from Ian Dingwall at the executive director's conference about some concerns that they had with firms who perform employee benefit plan audits and may not be undergoing a peer review. So just to kind of bring you up to speed, about a year ago, the Department of Labor contacted the AICPA and asked that they help them verify of the 4,900 plus firms that are doing employee benefit plan audits, which ones are enrolled in peer review. So the AICPA went through a process of looking through each of those and reporting back to the Department of Labor how many firms were enrolled, 3,907. There were 144 not enrolled, and there were 867 that they could not make a positive match on. You all are familiar that there's confidentiality revolving around peer review, so that was the kind of information that they could provide. Then the AICPA decided to do an internal review as well. And what they found during the internal review is they wanted to look to see on those firms that had performed employee benefit plan audits for the year ending 2011, which one of those firms that did that, did they include an employee benefit plan audit on their most recent peer review? And what they found there is that there were 1,162 firms across the country that did not. So obviously that's of concern. Some of those were understandable reasons, meaning they had just done their first employee benefit plan audit and they weren't up for peer review yet. So there were a few that were explained. But what they did was they researched each one of these. They pulled Form 5500s from the EFAS system that the Department of Labor has, got all their ducks in a row, and as they found individual firms that didn't appear to be in compliance, they then contacted the states and said, this firm does not appear to be in compliance. Here's the information we found. Please reach out to the firm and the prior peer reviewer. So our job then was to do that, confirm the information, and take a variety of steps. It may be that there was some problem with the data. Maybe the data in our system didn't match the actual report that was issued, which was, I think we noticed one of those in Tennessee. In some cases, they uncovered firms that were under peer review right now, and there was nothing in the scheduling information saying they had an employee benefit plan audit, so we handled some of those first. But in the end, there are several that have been doing employee benefit plan audits for years, haven't had them included in their peer review, and of course that's a concern. The AICPA peer review program has some substantial recall guidance, or very detailed recall guidance, in which the reviewers have the opportunity to review the report that they issued from a peer review perspective to determine if that should be recalled or not because it wasn't done in accordance with standards. So there are some peer review reports that have been recalled. In most cases, what's happening is these firms are, once the information is verified, they're basically told that you can agree to have another peer review within 90 days, and if you don't, then those documents will be recalled and go forward. So what we're experiencing is that firms are agreeing to another review in 90 days to get through this process. Going forward, the AICPA has made some quick changes in the past several months to help make sure this doesn't happen going forward. And some of those changes are when you have a peer review, there's a representation letter that the firm must sign and give to their peer reviewer. It used to state something to the effect of, all of our engagements are included in our engagement listing. Well, now it's very specific. It includes things from employee or ERISA audits, governmental audits, those types of things, so it's very clear. There's also, in the checklist that the reviewers use, there's very specific questions. Have you discussed with the firm any concerns with high-risk engagements? Confirm that they don't perform these, so there's some checks and balances there. Okay, in Tennessee, just quickly, we have been told that there are 23 firms in the state of Tennessee that are kind of fall in this bucket of noncompliance. So far, I've had to deal with 10 individually. We've had 2 peer review reports recalled. We've had 2 firms that had been undergoing engagement peer reviews, meaning they did not tell the reviewer that they did audits at all. And so we've had to turn around and have them have a system peer review. I have 5 that did not include employee benefit plan audits on their listing of engagements, but they did include other types of audits. And then the last one that I've dealt with was a data entry error. The report was issued correctly, but not entered into the system correctly. So I hope, does that cover what you were hoping that I would share with them?
Yes, thank you.
Okay.
Hey, do we have any, excuse me, go ahead, Vic.
Our peer review recalls public information?
No, that the firm is responsible for contacting anyone that's using that peer review report. That it has been recalled. So, no, they're responsible for sharing any of that information. And in other states where the peer review reports are available to the state board, then the states are contacting the state board and telling them that it's been recalled. But in Tennessee, the board is restricted from seeing the results of peer review, therefore I've been told not to make a report.
Are we able to have a report along that same line that says these people did not comply with the requirements and tell them they were doing any audits, and therefore were doing an engagement only that you were referring to? And do we have any teeth about, discipline in that case where they haven't been forthright?
I don't believe so. The way I understand the rules, it's anything found out during the course of a peer review is considered confidential, and we came about that information as a result of peer review.
Mark, does the firm have a duty to inform us if their peer review's been recalled? Wouldn't they technically be?
No, because they are still enrolled in a peer review program, and that is all that we require in order to have a firm permit. My question, Wendy, is when are they dropped from the peer review program?
Only if they did not have that replacement review. So if they don't turn around and have another review, which is what most are having, in 90 days, and they were dropped, then I would notify you.
But we're not going to be aware of any problem at all until they are dropped from the peer review program.
Basically, if they go get it taken care of within the 90 days, they're still in the program. Otherwise, we would be notified.
Exactly.
Okay.
What are they doing in the 90 days? Are they just having a peer reviewer come back in and look at those?
They're going through the entire peer review process again.
Totally?
Totally. They have to have
Everything?
it. So if their peer review is due 2 years from now, but this was uncovered, you have to have a peer review in 90 days, regardless of when your next due date is.
Just these types of
No.
engagements, it's everything.
Right, because as some of you know that are involved in peer review, it's not just engagement specific and a system review, it's about the whole system of quality control. So, yeah, they can't just go look in those engagements specifically.
Basically, our only triggers are going to be if they get kicked out of the peer review or leave or get kicked out of the peer review program, or if DOL takes any action that would be public in nature.
Right. And right now, from what I understand, DOL, when they pull work papers in themselves, if they find deficiencies, then they will report those individuals or firms to AICPA ethics. And I've seen investigations open there as well. The last thing that the peer review board did that I don't know that I explained very well, but let's say in the future we find out that a firm wasn't honest, because the new representation letter that you have to supply to your peer reviewer, it specifically says that if basically in the future something is found different and that it will be deemed failure to comply, and it will be deemed as a violation of Code of Professional Conduct, and you will be sent to ethics, which is something peer review does not do now, or had not done previously. So let's just say the provisions that the peer review board has just made to help with this issue in the future, and especially for states like us in our current situation, if I had a case today under the new provisions and I said you had an employee benefit plan audit that you did not share with your peer reviewer, I pull that representation letter where it says I've supplied this information to my peer reviewer, I provide that to AICPA, and they're turned over to ethics. So they would undergo the replacement review, but they now have a case open with AICPA ethics as well. That really wouldn't be based on the work performed, but just the fact that they lied.
Thank you, Wendy.
Any other business that needs to come before the board? I believe that's.
Mr. Chairman, the most mercifully brief portion of this whole deal comes right now. There is no legislative update.
Thank you.
There were no,
I thought that's what you were doing when you were reading.
There were no specific statutes that were passed relative to just the accountancy board. If there were any amendments to Title 56 that end up applying to all reg boards, we'll get some notice of that from up the food chain probably sometime this summer.
I appreciate that. I will entertain a motion to adjourn.
So moved.
All right. I don't think there's going to be any opposition to that.
Opposed?
We're adjourned.
Good rough meeting, sir.
Yeah, thanks.
Well done.
I didn't think that. Fancy that.
Yeah, it was